always, it's so good to have you here tonight. We're gonna dive right in right now. We have a verdict watch to start off this week out of the great state of Texas. Benjamin Elliott on trial in regarding the murder of his twin sister Megan, known as the Sleepwalking twin murder trial. Now, I can give you some portion of it, but the rest we're going to take you right to the courtroom. First off, a Texas man who had told police he was sleepwalking when he stabbed his twin sister to death has been convicted of her murder. Benjamin Elliott was 17 years old when he stabbed Megan Elliott in her bed in the early morning hours of September 29, 2021. He faces up to 99 years in prison, and the judge said the jury had asked for leniency if they found him guilty of murder. In recorded statements to police that were played for the jury in his trial, Benjamin said he awoke from a dream to find himself standing over his sister, who had a knife in her neck. He said he pulled the knife from her neck and called 911 to report that he stabbed her. Officers arrived at the family's home in Katy, Texas, after 4 a.m. and found Benjamin performing CPR on his sister. The knife, described in testimony as a survival knife that belonged to his father, was found at the scene. Benjamin was out on $100,000 bond since the incident. His lawyer chose not to deliver an opening statement at the start of the trial. In court documents filed before the trial started, Benjamin's attorney said they may call a sleep expert, a neurologist, psychiatrist, and a forensic science expert. Harris County Assistant District Attorney Maroon Kutani said in his opening statement that cell phone evidence contradicts Benjamin's sleepwalking claim, according to KENS. Prosecutors are also relying on Benjamin's police statements to support their theory that he knew what he was doing and intentionally stabbed his sister. So, the jury has asked for leniency as far as sentencing goes, but the final decision lies in the hands of the judge. So let's go to the courtroom right now and let's find out what is the fate of Benjamin Elliott.
When assessing punishment, I look at many factors that help guide me. This is a wide range of punishment: 5 years, 99 years, or life. I look at the criminal history of the defendant. I look at similar cases with fact patterns and what juries have decided, and there's none. I mean, we could all agree on that. And I look at what the jury has told me, and defense, they did not agree with your defense. I'm sorry, they didn't. However, unsolicited, they told me to be lenient with Mr. Elliott. I will tell you that, and I've told y'all that when I spoke with them. I didn't ask, they tell me. I look at cases I've tried as a prosecutor and defense attorney, try to look at similarities to see what I think is just. I look at mitigation, and in this case, and there's mitigation. I mean, there's no criminal history. He seems to be portrayed as a nice person. I can't argue with that. I look at aggravated circumstances. The complaining witness, if she was young, she didn't deserve what happened. I look at how the defendant behaved on bond. I sit there, and I've told everyone before, I see what people do, not what they say, and I just watch them, and just to see what they're going to do. And he's behaved. We can't argue with that. I think about the victim. I do. I will. And I have. I think about the victim's family, which is also his family. I think about the defendant's age. I think about rehabilitation, punishment. And I think about what I think is just and what I can live with. Because the bottom line is I have to be able to live with whatever sentence I give. And I take that very seriously. Stand up, Mr. Elliott. jury finding you guilty of the offense of murder. Your range of punishment is from 5 years to 99. I sentence you to 15 years in prison. At this time, you will go with the Sheriff's Department, where your sentence will be fulfilled in the Texas Department of Criminal Justice. And you'll get the credit that you have received while out on bond. If you served any jail time, you'll receive that credit as well. Is there any legal reason why this court should not give you that punishment at this time? Any legal reason, Mr. Rucker?
No, Your Honor.
With that said, please go with the Sheriff's Department where you fulfill your sentence in the Texas Department of Criminal Justice. Thank you all.
And there you have it. The judge sentences Benjamin Elliott to 15 years in prison, where he could have faced 99. And if you also note, this is 15 years. It's not 15 to life. It's not 15 with parole after a set number of years. It is a straight 15, which means exactly that. Benjamin Elliott in Texas will serve out 15 years of his life behind bars. So I guess in a way there's no other way around that. This is justice served. Alright, moving onward. Buster Murdoch's lawsuit against Netflix and others will be tried in Hampton County. A judge has ordered several media outlets must stand trial in Buster Murdoch's lawsuit, and the cases will be split between state and federal court. Buster, the son of convicted killer Alex Murdaugh, is suing the outlets of saying he was involved in the death of Stephen Smith at the center of the lawsuit. And there are three documentaries that focus on the Murdaugh family. First is a series produced by Blackfin Incorporated and broadcast by Warner Brothers Discovery Incorporated entitled The Murdaugh Murders: Deadly Dynasty. The second is a series produced by Campfire Studios Incorporated and distributed and broadcast by Warner Brothers Discovery and Warner Media Entertainment Pages Incorporated entitled Low Country: The Murdaugh Dynasty. And finally, a series produced by the Cinemark LLC and broadcast by Netflix titled Murdaugh Murders: A Southern Scandal. In his lawsuit filed last year, Buster claims each documentary alludes to him as Smith's killer, whose body was found along a rural road on July 8, 2015. Initially classified as a hit and run, the South Carolina Law Enforcement Division, or SLED, said that it had uncovered evidence leading them to reopen Smith's case during its investigation into the Murdaugh murders. Smith's death remains unsolved and no one has been charged in the case. Last week, or should I say the week before, a federal judge ordered 4 defendants to stand trial in Hampton County: Netflix, Cinemark LLC, Gannett Company Incorporated, and local reporter Michael M. DeWitt Jr. Other defendants, including Blackfin Incorporated and Warner Brothers, will stay in Charleston Federal Court. Buster is the sole surviving child of Alex and Maggie Murdaugh. Alex was convicted and sentenced to 2 life sentences for murdering his wife and younger son Paul on the family's property in Moselle in June 2021. Buster testified during his father's 2023 trial and spoke out following his father's conviction. Buster maintains his belief that Alex is innocent and Maggie and Paul's killer is still on the loose. So now we got. So basically, what we have is possible. What's the word I want to use? Possible slander, or is it just truth being put on screen? There's a lot. There's a lot to unwrap, and hopefully it'll be unwrapped soon. That way we can figure out exactly what's what and who's doing what. What as far as this lawsuit goes. Next up, Todd Mullis is seeking to get his conviction thrown out for his wife's murder, and he's back in court for a post-conviction relief hearing. Mullis is seeking a brand new trial in his wife's corn rake death. Todd Mullis is fighting for a new trial in his wife's death and is back in court for a post-conviction relief hearing. In 2019, Todd was convicted of first-degree murder in the death of Amy Mullis. He was sentenced to life in prison without parole. During his criminal trial, prosecutors argued that Todd killed Amy after learning of an affair she was having with Jerry Thrasher. The couple's son found Amy in a shed with a corn rake impaled in her back. Todd removed the rake and began driving her to the hospital until a 911 dispatcher told him to pull over and let first responders meet them. Prosecutors argued he called Amy a cheating whore in the 911 call and played it multiple times in court. Prosecutors zeroed in on Google searches made on the family's iPad, claiming they were made by Todd. The defense insisted the searches were not suspicious and everyone in the household had access to the iPad. At the start of Todd's post-conviction relief hearing, Todd's new attorney stated he is insistent that Amy's death was an accident and that at trial he didn't have any way to present evidence to the jury that it was an accident. His defense called the first trial fundamentally unfair and claimed prosecutors withheld evidence. Court documents state from the moment he observed Amy Mullis unconscious on their family farm, Todd consistently told 911 first responders, law enforcement, and his trial counsel that Amy must have fallen onto the tines of a corn rake that caused her death. Nobody listened to him, including his trial counsel. Todd's attorneys are asking that his conviction and sentence be vacated and he be given a new trial. The hearing is expected to last multiple days and include testimony from multiple witnesses, including depositions from Todd's trial attorneys. And I can say this because I have actually seen clips of this on A&E's court count. Every time I hear that tape where where you can hear a voice crackling on the tape, where Todd Mullis could be heard calling his wife a cheating whore. I can hear it, but I can also hear him I can also hear and see him on the witness stand using what I like to call the Shaggy defense. In case you don't know, ladies and gentlemen, when I refer to the Shaggy defense, I refer to the phrase "it wasn't me." Excuse me, guys. Trying to get my camera straight here. And still ain't got it. Alright. That ought to do it. Just one more little turn. And that'll do it. Okay. Todd Mullis is on the witness stand, and he is still using the Shaggy defense. What I mean is, when you hear the voice on the recorded tape, on the recording calling his wife a cheating whore, he is still saying to this day, "It wasn't me." When it comes to the possibility that he was the one that took that corn rake to his wife's back, again, he is saying, "It wasn't me. It wasn't me." And he's going to keep on using that defense until he's looking to he will probably get that new trial. I wouldn't recommend it, but that's what could happen. He gets that new trial, and if he gets it, it may not work out well for him, because usually defendants who get a second trial usually end up being found guilty again, which could very well end up being a life sentence again. Parole? Nope. So basically, he's really rolling the dice here. So to Todd Mullis, all I can say is, good luck, buddy. You're going to need it. And we have fireworks in the courtroom. After refusing to accept a plea agreement in the Timothy Hochschultz trial, the Honorable Judge Geraldine Dietz denied a motion to reconsider and to recuse. So Outlaw, where's the fireworks? Be patient. This is the breakdown of said fireworks. In a flurry of rapid-fire motions, a Wisconsin judge went head-to-head with both a prosecutor and a defense attorney in a battle over a plea agreement and whether to delay a pending murder trial. Timothy Hochschultz was scheduled to stand trial on last week on 6 charges, including felony murder and abuse of a child, for the death of a child in his care in 2018. In the charging documents, prosecutors say that Hochschultz used his then 14-year-old son to abuse other children in his care. Ethan Hochschultz, age 7, died after he was beaten, forced to carry a 44-pound log in the yard, and was buried in 80 pounds of snow. Timothy, who was not home at the time, admitted that he directed the child to carry wood, but denied any abuse. At a pretrial hearing on February 20th, the prosecution and defense told Judge Geraldine Dietz that he had reached a plea agreement to resolve the case. Under the terms of that plea, Timothy would have pleaded guilty to 2 counts of child abuse, and the other charges would have been dropped. Dietz rejected the plan, saying that it was not in the public's best interest. The parties returned to court to resolve the other outstanding motions ahead of trial, but both the defense and prosecution returned to the plea agreement. Both sides referenced motions filed under the seal over last weekend, asking Judge Dietz to reconsider her ruling. The defense accused the judge of making her decision without hearing from them and implying that she wanted a sentence higher than the 12-year maximum plea agreement would have allowed. Judge Dietz explained that the sentence was not the issue, but rather she could not understand why the state was dropping 4 charges, including felony murder. Immediately after the ruling, the defense introduced a motion A motion unopposed by the state asking Judge Deeds to recuse herself. Timothy's attorney accused the judge of bias, to which a clearly frustrated Judge Deeds responded, "Then you haven't listened to anything I've said." Judge Deeds immediately denied the motion, refusing to withdraw from the case. That ignores half of what I said and half of the reasoning. It ignores the other factors that I talked about at great length, Judge Deeds said. It ignores the discretion that I have, and it ignores my obligation to independently review any plea agreement that you do not like. The ruling does not make it an improper ruling. Timothy's attorney then immediately fired back with another motion, an emergency motion to adjourn and stay proceedings so that they can appeal the judge's decisions to a higher court. Prosecutors said they did not oppose the motion, emphasizing their concern only with appellate issues and the desire to put victims through only one trial. Judge Deeds appeared reluctant to accept the motion to stay the trial, saying, "Quite frankly, springing these on me at the last minute is unfair." She said she would consider the motion and return after taking a few hours to review it and relevant case law. Returning after a recess, Judge Deeds appeared poised to deny the motion to stay the trial and began to talk about jury selection beginning Tuesday. But a brief back and forth with the prosecutor about victims in the case turned into an extended sidebar out of the courtroom. And when the parties returned, Judge Deeds announced she was granting the motion to adjourn and stay the trial. The parties are scheduled to return to court next week to discuss further scheduling matters. Well, at least I give Judge Deeds her respect for standing her ground. I mean, come on. There is so much going on this. It's not funny. First off, the guy is scheduled to stand trial on 6 charges, including felony murder and abuse of a child. So how do we go from all that to a plea agreement where he pleads to 2 counts of child abuse and everything else, including the felony murder charge, gets dropped? Come on! That makes no kind of sense. None. Anyway, when this case is updated, I'll be sure to bring you the details in that. But then again, that's all a part of my other motto, as you can see on your screen. My guarantee of no gimmicks, no drama, and no BS. And trust me, from the way this particular case is going, there's a lot of BS that needs to be uncovered. Next up, a Karen Reed update. This time, her attorneys is going to return to court on this coming on this blah blah blah. Wait, let me get my tongue untied here. Karen Reed and her attorneys returned to court to continue a hearing suspended by the judge's grave concerns. This is one of another report that I also have. I'll feature later on in this broadcast. Oh, this might help us a little bit. So what I'm going to do, I'm going to step out, and I'm going to take you right to the courtroom where the Karen Reed's defense remains in limbo in a battle over ethics and trial experts. Excuse me.
And when we were sidebar, I specifically mentioned, I don't know, about here is inconsequential. I don't know what to ask. I can't send them back home to get their records or their emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses, and there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th, where ARCA is actually billing the defense for their works before the voir dire. There had to have been communication between that time that rekindled this relationship. There are two requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Mr. Lisi, what you should do, what the court should do, is go to the federal government and ask
So
questions.
just to be clear, I am not having ex-parte communications with anyone about this case. So I'm totally rejecting the request that I do that, Mr. Lisi.
It wasn't a request, Your Honor.
You suggested that I called.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but the point is it is not incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that ARCA's position did not change, it did change. Their opinions did change by the time they reached trial. It is not that the defense brought out that there was an expert providing on crashes happen at night. It is the bias, the relationship that is critical, and that was hidden from the court, the Commonwealth, and the jury. It is the bias and the leaning towards one side that was not disclosed. No, the first trial to disclose it last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to court, I believed the documents provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my two requests. They provided billing, including ARCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not correctly. No bills other than what the ARCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth our motion to exclude the ARCA witnesses. On February 12th, the United States Attorney's Office gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now, I did misspeak, I corrected it, but it is not the source of that information. It is the substance of that information which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial. And it is also that information, when you compare it to the representations that have been made prior to trial by the defense, that has import. Before, and I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider pro hoc vice. We have one licensed attorney in Massachusetts who's carrying 3 pro hoc vice attorneys with the request for a 4th to ride on that same license. There is a responsibility, respectfully, to Attorney Inetti. He's a fine attorney, an excellent attorney who I admire. But there's a responsibility so that there are not a number of pro hoc vice lawyers doing different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through with a bar card on that table. And so to try to parse or mince or put a slight on words to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alisi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal material. And there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through TUI requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge, essentially, of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask the counsel if there were any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over there,
inquire.
please.
Yes.
All right. If I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I've heard.
May I have a moment to speak to counsel?
Sure.
Thank you, Mark.
I'll need to call the United States Attorney's Office and get an answer.
All right. I appreciate that. Sorry to interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replies on the 24 saying the U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like it would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the board here, where it was asked, were you available to the Commonwealth? And the witness said yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses. On June 5th, 2024, day 26 of trial.
What date?
Day 26
You
of
know
trial.
that, but what date?
June 5th, 2024, discussing scheduling and voir dire hearings. The defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows, and I make those decisions. Response, certainly, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report, he's got the report, that's it. I'm going to start asking questions on the report, that's it. He can cross the report, so as many times as he says, I don't know what they're going to testify to, yes you do, because they're going to testify to the contents of the report, and those are definitely questions I'm going to ask, so I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? There's date. I'm sorry. What's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number from the court.
That's okay.
This seems to directly contradict the theory that Attorney Lisi has been promoting today of the rules of the road. This does not suggest that ARCA is open for business and private discussion and consultation and payment. It says the opposite. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Lisi, suggesting somehow that this was open and notorious, is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts in ARCA, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, and this is June 10, 2024, trial transcript 28.
Hold on one second. Let me click that.
I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when you look at the ARCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continued questioning, you were told, well, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for the purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important to the defense. And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided. on June 18th, 2024. The voir dire hearing. The court asks, well, I thought that you would help.
I've got the transcript. What page you on? Do you know?
No, but I can.
If it's just your notes, that's okay.
I can pull it up. Your Honor. Page 4, line 11, the court asks, so the understanding of the voir dire is that this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rensler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case. And the answer is that's correct. Now, refraining from my opinion and characterizations, unlike the defense, I think that the transcript speaks for itself. I'll let it speak for itself. When we continue in the voir dire hearing, page 71.
Okay.
Line 4. Importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked into court, had you and I ever met face to face? No, sir. Now, this illustrates an important point. That is technically true. But what impression is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality? Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce that the defense and ARC are wholly independent from each other. This is also consistent with the representations regarding payment. There are questions voir dire and at trial about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement. It can show bias. There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence, information about them, then it is not a fair representation. It is not an honest representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice dated July 12, 2024. It's addressed to...
Hold on one second, please. Okay?
It's addressed to Attorney Jackson, and the position that the defense takes, Attorney Lisi takes today, is this came out of the blue that they had to pay. Apparently, everybody in the know knew the defense was paying for this expert, other than the defense. Arakawa experts knew, Dr. Wolf knew, Dr. Rentschler apparently knew, the federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representations that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, and they wouldn't have been keeping track of their time back on May 1st, 2024, participating in a telephone call with Alan Jackson. And so the March 20th email asking for an engagement letter and a retainer, and then the 24th saying we need to take a step back because the U.S. Attorney's Office,
22nd.
I'm sorry, 22nd and 24th, there is obviously more communications because the relationship re-engages at least on or before May 1st, 2024, and these witnesses understand that they're going to be paid by the defense. And as I mentioned in the materials we got from the United States Attorney's Office on February 12th, there is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised that they were paying the witnesses apparently was the defense themselves. And then before that June 10th hearing where the representations were made, there's a June 9, 2024 phone call. Another participated in telephone call with Alan. And then we see before the voir dire testimony, there is billing to the defense, which is now paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about the potential testimony, or is this solely the preparation of Dr. Rentschler on his own? On the same date, 3 hours billed by Dr. Wolf, prepared for testimony and hearing. Now, they felt inclined and comfortable billing the defense for. Was there any interaction or discussion between the parties? We don't know. This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rentschler, and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Rentschler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rentschler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on the potential testimony, it is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of being paid. In fact, it's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time. Also billing for wait time and travel, testimony at trial on June 24th, and there's expenses for June 18th and June 24th. specific expenses, $1,749, $1,932. So they are keeping very careful track of the bill that they send within 1 month of the defense that gets paid that Commonwealth and the court never knows about. Talking about correcting a record. And so this $23,925, we find out today, it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit, we have no witness, we have no writing, no email, no correspondence, nothing to support, put in context the conversation, nothing. No. And so when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story. A fraction. It's not enough to blame the court, blame the Commonwealth, blame the U.S. Attorney's Office. There's some accountability. In addition, when you look at the totality, the representations made in court, we also, at some point, are going to address the Commonwealth's position of violations of 3.6, separate motion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asks Mr. Jackson about paying the bill. What I suggest, more 3.6 activity. Quote, no, of course not. That was the position last week. So what we're left with is we still don't know the relationship between the defense and Arakawa. We don't know about the impact it had on the first trial. There has been these multiple representations that Arakawa was independent, they had their opinions, and they were exculpatory. Arakawa's opinions changed. There were 4 opinions. And if you look at their report, and I'm not going to read it for the sake of the press and the public, we'll have a trial, and we'll vet it at trial. But when you read the report, clearly the representations made about that report were extended at trial. And the question is going to be, why? Why did they improve? Why did they...
Particular page you might be able to have without citing.
Yeah. If you look at the first page,
Yes.
yeah,
You don't have to read any of it, you just tell me the paragraph.
Yeah, I think it's just the first paragraph that lays out their findings.
Thank you very much.
and actually particularly note number 4, and both publicly, repetitively, but also at trial, the parameters of that were extended substantially. There is a summary again at the end of that report. Substantially says the same thing if you look at the last page, which is signed by all 3 of the experts, Mr. Wolf, Mr. Renshaw, and Mr. Klein. Says essentially the same thing. So we'd be oblivious if we stood here and said that the relationship between the defense and the experts, there's no relevance to bias or motive or desire to please, because clearly there's a change, there's an expectation of payment, there's communication, and to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared. It isn't just what's in that outline. It's the fact that they have the relationship Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, 3 of them, in the outline where the ARCA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair. So we know there is more. The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it, and the TUI letter is not going to be thorough and complete. It's just not the way TUI works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations, communications the defense had with the experts that the federal government doesn't know about. Over the next few weeks, we're going to attempt to get more information, but we will never have an accurate accounting unless it's compelling. Your Honor has mentioned the sidebar,
Which one?
the most recent one.
Okay.
I'm not trying to be overly critical of another attorney. I'm not. You can laugh, but I'm not. It has been my effort to get Rule 14 material. It has been my effort not to exclude ARCA witnesses. It has been my effort to try to achieve fair play. There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
All right. Thank you. Mr. Leslie, very briefly, if you have something.
Yes, thank you, Your Honor. I'll be very brief. And I hope we get an opportunity to have a more fulsome response, but I'm going to be very brief on the key points. Attorney Brennan focused a lot on the invoice. As I said, I work with experts all the time. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation that they had been retained by the government. They were being paid by the government. They maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to be providing testimony. That's a whole different issue, what they expected to be paid and by whom from what the defense expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And the entries, all that Mr. Brennan went through, particularly the early ones, there is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. It is very important because Attorney Brennan spent most of his time on that invoice. With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it, we don't have some of the things that Mr. Brennan was referring to, but he referred to, of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court. But to be clear, the reporter asked, did you pay for testimony? did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
All right, so you just told that I paid for their time. That was not said, right?
That was not said, but I'm saying there's always some inference about because what he said, that what was said, but that was his response, that was it. But it was only, the premise of Attorney Brennan was, what Mr. Jackson said to the reporter was different from what you've heard in court today, and it wasn't. It's important to be accurate. The other things that I'm going to go through quickly is it kept stating that there had to be a belief that they were going to be paid by the defense. There is no evidence whatsoever for that because it didn't exist. So now with regard quickly again to the other topics. Attorney Brennan talked about 3 witnesses, right? And he said he was, I believe I took it as clearly inferring 3 Arakawa. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 Arakawa people. I
No.
go back to the transcript.
You can go back to the transcript. Earlier on, there was a discussion, way early on.
Who is Mr. Klein?
He was a 3rd ARCA expert that was involved for the government, right? And then he stopped, and we didn't retain him for testimony.
Okay.
Let me be clear on what I mean by retain. He didn't testify.
It's been a long day.
I understand. I'm trying to answer your question, Your Honor.
I know, and I realize that you just said something that you want to explain. Go ahead and explain.
Right. So what I'm saying is, in terms of, I'm going to take back the retain. The point is, there were originally 3 ARCA persons on the report that we got from the government, right? Rentschler, Wolf, and Klein. We only went forward with the testimony of Rentschler and Wolf. And that's what I want to come to, Your Honor. The whole emphasis was that the Commonwealth had no notice that we were going to use these experts. Your Honor, the voir dire was the notice. And my point was, I didn't say that there was no bias. What I said was, once you decide you're going to use an expert, right, you're going to be having them testify. Anybody could claim that that testimony is biased. But the point is, Your Honor, that the allegation that somehow mysteriously this 3rd person that was being discussed, and clearly the inference was that we were misrepresenting still about which ARCA witnesses because we weren't talking about the 3rd. The 3rd was Dr. Russell, and you'll see that in the transcript.
Okay, but when I said you expect something, whatever I said, you expect me to believe that you are calling 3 witnesses whom you've never spoken to. When I had that discussion with Mr. United, that's what I meant.
Thank you for bringing that up, Your Honor. And that was just ARCA. That was nothing to do with Dr. Russell. But here's the important part. Attorney Brennan didn't read the rest of it. You're to believe.
Okay, so where are we? Are we the June 10th?
Yes, please, Your Honor. June 10th. That's exactly right. That's exactly right. It was June 10th. It's important. He stopped when he made.
Page 12.
Yes, thank you. So on June 10th, so you're to believe, this is line 19, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. Here's the response in its total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation. It was. We've spoken to them only for the purposes of coordination of their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the report. Your Honor, that's 100% true, because
I read that earlier.
Right, but Mr. Brennan just mischaracterized it again, because that is 100% true. He made it seem like that was an untruthful statement, and I know Your Honor gets it. The other last 2 points, Your Honor. Attorney Brennan talked about that the ARCA experts improved their testimony. My point, Your Honor, was their opinions never changed. Whether they improved is a characterization, but their opinions did not change. And that is very important. And the last point, Your Honor, goes to the discussion that Your Honor was having with the questioning of Ms. Little, Mr. Jackson. I want to be very clear on February 6th, and this is going to be my very last point. When Your Honor asked the questions on February 6th, and Mr. Jackson responded about the discovery, and I said to you that Ms. Little was the one handling the discovery. And I spoke with Ms. Little and I spoke with Mr. Jackson, and they're going to be completely available for any questions that follow up on this. I asked Ms. Little during the break. She wasn't here for that February 6th. She obviously didn't hear the sidebar. But I said, when you learned of what the Judge Pennoni was asking about, I said, in your head, what was going on and what came to your head? Because I said Mr. Jackson didn't make any knowing misstatement because he had no recollection of any of those March emails. So I asked Ms. Little, who would, between the two of them, would, if there was any recollection. So during the break, I asked Ms. Little, I said, Ms. Little, when you heard, and got the order, because that's the first she knew of the inquiry, she gets the order, I said, when you got that and you saw that you had to turn over discovery, when you read that, did it come to your mind? Did it come to your mind that there are these March emails? And she said, no. I didn't recall them. I didn't remember their existence. And what I did was I knew we had to turn over discovery. I then went back. I rediscovered those emails, and that's how I had recalled it. That is important, Your Honor, because there has to be a knowing misstatement of fact for 3.3a. So not only did Mr. Jackson not know at the time Mr. Jackson made those statements and recalled those emails, neither did Ms. Little, who was the keeper of all the discovery. And that is my last point, and I will conclude this way, Your Honor. Attorney Brennan conflated Rule 14 issues with the 3.3A1 issues. They are completely separate. I am not here today, Your Honor, to take the position that the defense is in perfect compliance with Rule 14. We're not. But that's a whole different question from whether the attorneys are in compliance with 3.3A. And I would urge Your Honor, as I know you will, to keep those distinctions as we go through the matter, because conflating them is not proper for the analysis. And my last is a citation of law, Your Honor. It was said that Gonzalez involved a very minor issue. Attorney Brennan is correct. There was a minor issue in Gonzalez, but the Supreme Court went through those things that could rise to it, and I'm going to give you another cite, Your Honor, which is United States versus Diazzi, that involved a lot of serious issues with regard to conduct of counsel. They were not pro hoc vice, but it's 807 Fed 2nd 12 First Circuit 1986, where Your Honor can read it as to what were happening. The attorney's conduct was deplorable, and yet the court held that you could not disqualify them because of the Sixth Amendment. And my last point, Your Honor, is when you do a Sixth Amendment analysis, whether or not the attorney at issue is pro hoc vice or not, is not weighty in the determination of balancing the Sixth Amendment. It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where a defendant or choice of counsel, that is a much different analysis with the Sixth Amendment. So I will stop there, Your Honor, because you said to be brief. There would be more I would have to say, but those are the highlights for the moment.
Anything, Mr. Brown?
Very briefly. My arguments to the court have always been focused on Rule 14. The verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So let's use the defense words themselves. If you look at docket 505, which was signed in a pleading,
That was filed late, right? The
February
or
6th.
Saturday or something.
February 16, 2025. This sums it up, really. And this is signed by Attorney Jackson, Attorney Alisi, Attorney Manetti, certificate of service by Attorney Little.
Was it signed by Ms. Little? It's not,
Ms.
right?
Little has only done the
Maybe
certificate of
authored
service.
by- Okay.
She did not sign it. It was signed by Attorney Jackson, Alisi, and Yanetti. And this is the defendant Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCA LLC. And here's the representation they made. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCA LLC, namely Daniel Wolf, PhD, and Andrew Rentler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. I know Attorney Alisi no longer likes the word retain, but that retain word has import. The reason he said it. Their words, their motion. This is no different than the tone of representations made February, last June, May, and before. Thank you.
All right. So we're back here next week. I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As the court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court
What
at
time?
9:30 in the morning.
Okay.
Could we possibly go there and then
Yes.
come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here, Jim. We have these all scheduled at 9.
We do.
Okay. All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course I'll let you go to federal court first, and also Friday. All right, so see you next week.
Back and forth but as far as this arguments go, and it's still not complete yet. They're going to continue this on Tuesday, and I got a feeling it's gonna keep on going until there's some kind of resolution before the retrial begins. So let's be ready for that. And in another case to be ready for, jury selection has already started in the case of the Illinois January 4th parade shooting suspect. Robert Cremo III is the man accused of opening fire on a suburban Chicago 4th of July parade, killing 7 people. Cremo is about to stand trial. Alright, jury selection started last week after several delays. Part of the reason is the erratic behavior of the defendant, Robert Cremo III, which has raised questions about what to expect at trial for the 2022 mass shootings. Opening statements are expected to start this week. First off, let's break this whole thing down. First, the attack. Authorities allege a gunman perched on a roof shot at crowds assembled for a 4th of July parade in downtown Highland Park, a wealthy suburb 30 miles from Chicago. 7 people were killed in the 2022 shooting. including both parents of a toddler. Dozens more were wounded. They ranged in age from their 80s down to a then 8-year-old boy who was left partially paralyzed. Witnesses described confusion as shots rang out, followed by terror as families abandoned the parade route, leaving behind lawn chairs and strollers to find safety inside of homes and businesses. City leaders canceled the parade the following year, but reinstated it in 2024 with a memorial to the victims. Mayor Nancy Rotering has said the city doesn't want to be defined by the mass shooting. This month, she announced the parade will return in July, but without fireworks, partly because of community trauma. This year's parade theme reminds us that teams bring people together in support of a common goal, and that we are most resilient when we support each other, Roderick said. Killed in the shooting were 64-year-old Catherine Goldstein, 63-year-old Jacqueline Sondheim, 88-year-old Stephen Strauss, 78-year-old Nicholas Toledo Zaragoza, 69-year-old Eduardo Uvaldo, and married couple 37-year-old Kevin and 35-year-old Irina McCarthy. The case. Cremo was initially charged with 21 counts of first-degree murder, which is 3 counts for each person killed, as well as 48 counts of attempted murder and 48 counts of aggravated battery. But on last Monday, Lake County prosecutors sought to drop the less serious aggravated battery counts. They briefly noted the move ahead of jury selection without any explanation. Lake County Judge Victoria Rossetti signed the one-page order to dismiss the charges. The Lake County State Attorney's Office declined to comment. Prosecutors have turned over about 10,000 pages of evidence as well as hours of videotape interrogation during which police say Cremo confessed to the shooting. But the 24-year-old Cremo has since pleaded not guilty and rejected a plea deal. Court proceedings have made parts of the interrogation public, and defense attorneys tried unsuccessfully to have the videos thrown out, alleging Cremo's rights were being violated. Videos show officers repeatedly asking Cremo if he understood his Miranda rights, which include the right to remain silent and have an attorney present. "I've heard him a million times," Cremo said at one point. Prosecutors have also shown footage of a person dressed in women's clothing and identified by police as Cremo headed toward the parade route on the morning of July 4th, 2022. Something that could also hurt the defense is Cremo's unpredictable behavior in court. He didn't show up to 2 previous court hearings, refusing to leave his Lake County jail cell, and in June 2024, when he was expected to accept a plea deal and give victims and relatives a chance to address him publicly, he showed up to court in a wheelchair and rejected the deal, surprising even his lawyers. He also fired public defenders and said he would represent himself, then abruptly reversed himself. "Anything could happen at this point," said Eric Johnson, a law professor at the University of Illinois. Cremo's defense attorneys and Lake County prosecutors have repeatedly declined comment ahead of trial. Last Monday, Cremo appeared in court wearing a suit and tie, clean-shaven and with his hair cut short. He occasionally looked at jurors as they were being questioned and appeared to be jotting things down on paper. But Cremo did not return to the proceedings after a lunch break. Police officers escorting him told the judge Monday that Cremo said he would not return to the courtroom in the afternoon. Cremo's parents, who had been sitting behind him in the morning, also did not return for jury selection in the afternoon. Now let's look at Cremo's family. Robert Cremo Jr. pleaded guilty in 2023 to 7 misdemeanor counts of reckless conduct. The charges focused on how his son obtained a gun license. In 2019, at age 19, Cremo was only allowed to apply for a gun license with the sponsorship of a parent or guardian. His father agreed, even though a relative had reported to police that his son had a collection of knives and had threatened to kill everyone. Robert Cremo Jr., a one-time mayoral candidate and former owner of a now-closed deli, has attended his son's court hearings, making eye contact with him during hearings. He declined to discuss the case in detail. As a parent, I love my son very much, and Bobby loves this country more than anyone would ever know, he said during a phone interview. I have no further comment. Now, a possible makeup of the jury. Potential jurors reported to the courthouse in Waukegan on last Monday. The process began slowly, first with filling out extensive jury questionnaires, followed by questioning by the judge and attorneys. More than half a dozen jurors were chosen Monday. Jury selection for the panel of 12 and 6 alternates is expected to last several days. Opening statements are scheduled for next week in what attorneys expect to be a roughly month-long trial, but the high-profile nature of the case could complicate efforts to find a jury. All those who appeared for questioning had heard of the shooting when it first happened, even one who was traveling to Greece at the time. One potential juror said he was near the parade on the day of the shooting and knew someone who was shot. He was dismissed. Another man, a retiree, said he read many articles about the case and it affected him deeply. I saw a lot about it on the news, he said. You couldn't avoid it hardly. He was also dismissed. Survivors and their families have filed multiple lawsuits, including against the maker of the semi-automatic rifle used in the shooting and against authorities they accused of negligence. Those who have spoken out declined interviews ahead of the trial. Some are expected to testify, along with police and a former school resource officer who encountered Cremo during middle and high school. Experts say attorneys will have to approach jury selection with extra care. There is information that's out there, said Alan Turkheimer, who consults lawyers on jury strategy but isn't involved in the trial. This is the kind of thing that has affected people in the community. And as you're taking a look, here's a memorial for all that was made for all those who were affected in that mass shooting. Here's another shot of handwritten signs, painted signs, rocks dedicated to the 7 people killed and the others injured in that shooting. And the next 4 shots you're about to see is Robert Cremo III in court. This guy here looks like he is very unpredictable. You never know what you're gonna get. And as you can see, right above his eye is a tattoo with the word "awake" on it. As far as my opinion on this guy goes, like I said, this is going to be a very unpredictable trial with an unpredictable guy. So we'll just have to wait and see what happens as we go forward in that case. Okay, we went through the sentencing with Benjamin Elliott, and we've heard we went through the defense remaining in limbo and battle of the experts and ethics. Next up, the prosecutors are seeking to limit Brian Kohlberger's evidence at his murder trial coming up. Prosecutors are saying that Kohlberger should be allowed to offer an alibi defense unless he takes a stand himself at his murder trial. See, Idaho prosecutors say a man charged in the stabbing deaths of 4 University of Idaho students shouldn't be allowed to offer an alibi defense unless he takes a stand himself during the murder trial later this year. Latah County prosecutor Bill Thompson asked the judge to limit any alibi evidence during Brian Kohlberger's trial in a court document released last week. He asked 4th District Judge Stephen Hippler to limit evidence about any psychiatric evaluations Kohlberger might have undergone, as well as arguments about an alternate perpetrator of the crimes. Ooh, excuse me again. Kohlberger is charged with 4 counts of murder in the deaths of Ethan Chapin, Xana Kernodle, Madison Mogan, and Kaylee Gonsalves, students who were killed in the early morning of November 13, 2022, at a rental home near their campus in Moscow, Idaho. When asked to enter a plea last year, Kohlberger stood silent, prompting a judge to enter a not guilty plea on his behalf. Prosecutors have said they will seek the death penalty if Kohlberger is convicted. Thousands of pages of court documents have been filed in the complicated case as attorneys on both sides attempt to set ground rules for what will and won't be presented to jurors during the 3-month trial set to begin August 11th. Kohlberger's defense team filed a court document last year that said he was out driving in the early morning hours of November 13, 2022. As he often did, to hike and run and or see the moon and stars. The defense also said an expert in cell phone tracking would partially back those claims by testifying about Kohlberger's mobile device during those hours. But Latah County prosecutor Bill Thompson wrote in his motion that the defense team hasn't provided enough specific details about exactly where Kohlberger claims to have been, and that they failed to meet disclosure deadlines set by the judge. It would be unrealistic at this stage, at this late date, to expect the state to effectively investigate any and respond to any new or additional alibi-related disclosures, Thompson wrote. So any alibi evidence should be barred unless it comes from Kohlberger himself. Thompson also asked the judge to limit the defense from offering any arguments about other possible perpetrators unless the judge first decides the evidence is relevant and admissible in court. In this case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement, with the exception of information regarding the defendant. None of these tips were substantiated, Thompson wrote. He also asked that some testimony on neuropsychological and psychiatric evaluations of Kohlberger be barred, arguing it's not allowable under state rules. Defense attorney Ann Taylor, meanwhile, asked the court for permission to file a lengthy court document that will include motions on a variety of things, including improperly disclosed expert testimony, references to touch and contact DNA, and witness identification by bushy eyebrows. The judge approved Taylor's request to file the long document, but it has not yet been released to the public. So, what goes in, what goes out, what stays out? That's a lot to get through, and still plenty of time to get through it. August 11th is coming, but August 11th is coming up quickly. Hang on tight, guys. We're going to be in for a bumpy ride. We're going back to Illinois for this next story. An Illinois landlord is on trial for murder and a hate crime in the death of a 6-year-old. Joseph Zuba is accused of killing Wadi Al-Fayoumi, a 6-year-old Palestinian boy, and wounding his mother in a hate crime. Looks like this might be one to set up the old trigger warning. Yeah. Okay. Okay. A suburban Chicago Muslim mother described to jurists how she hid in a locked bathroom and called 911 after her landlord brutally attacked her with a knife and then fatally stabbed her young Palestinian American son in another room. Hanan Shaheen was the first witness to testify at the murder and hate crime of 73-year-old Joseph Suba. He is charged with wounding Shaheen and killing her 6-year-old Wadi Al-Fayoumi in October of 2023. Authorities say Suba targeted the family because of their Islamic faith as a response to the war between Israel and Hamas that erupted on October 7, 2023, with a Hamas attack on southern Israel. Prosecutors played the emotional 911 call Shaheen made to report the crime that happened just days after the war started. "The landlord is killing me and my baby," she screamed to the dispatcher multiple times, according to a recording of the call played in court. "He's killing my baby in another room." Zuba has pleaded not guilty to 3 counts of first-degree murder, one count of attempted murder, and other charges. He wore a suit and tie to court, his graying hair falling past his shoulders. Later, it was tied into a bun. Zuba did not speak as he watched the proceedings. One of his Will County public defenders, Kylie Bellotti, urged jurors to consider each piece of evidence carefully because key parts were missing. "Go beyond the emotions to carefully examine the evidence," she said during opening statements. "It is easy to get lost in the horror of those images." The family had been renting 2 rooms from Zuba and his wife, who also lived at the home where the murder happened in suburban Plainfield, nearly 40 miles from Chicago. Prosecutor Michael Fitzgerald, a Will County Assistant State's Attorney, told jurors they'd hear explicit details about the crime, including how Zuba removed a knife from his belt holder and attacked the family. Fitzgerald described each of the 26 stab wounds to the boy's body. "He could not escape," Fitzgerald said, facing jurors during opening statements. "If it wasn't enough that this defendant killed that little boy, he left the knife in the little boy's body." Shaheen testified at the courthouse in suburban Joliet, about 45 miles from Chicago, that she had not previously had any issues in the 2 years they had rented with Zuba. They shared a kitchen and living room with the Zubas. And then after the start of the war, Zuba told her that they had to move out because Muslims were not welcome. She urged him to pray for peace. Later, he confronted Shaheen and attacked her, holding her down, stabbing her and trying to break her teeth. He told me, "You as a Muslim must die," said Shaheen, who mainly testified in English, but had an Arabic translator on standby in her primary language. She occasionally turned to the translator for clarification while testifying, but during cross-examination she sought more direct translation, often addressing her translator, who sat next to her instead of attorneys. Defense attorney George Leonard asked detailed questions about conversations she had with police at the scene and while she was in the hospital. But Shaheen said she didn't remember specifics. At times, it appeared as though she had trouble understanding what Leonard was getting at. After the attack, Shaheen says she was scared and locked herself in the bathroom. noting blood all over her body and the room. She called 911 when she heard her son screaming in another room. Yelling could be heard on the background of the call, which Shaheen said was her son, as the roughly 15-minute recording played in court. Shaheen put her head down, clutching a tissue paper in hand. Attorneys showed photos of her bloody face at the hospital. She seemed shocked, very quiet, testified Sean Kozak, a Plainfield police officer who was first at the scene. She was trembling and kind of staring. The boy, whose name was initially spelled Wadia with an A, Al-Fayoumi by authorities, was later pronounced dead. Shaheen had more than a dozen stab wounds, and it took her weeks to recover. Victoria Janovac, a Will County Sheriff's deputy who found Wadi's body, wiped away tears as jurors watched the footage. The video screen was turned away from observers, including reporters and members of Wadi's family who were gathered, but the shock of the officers on the footage was audible. Some could be heard yelling profanities and "Oh my God" as they saw the boy's stab wounds. Another officer testified the knife was still in the boy's body. The attack on the family in Plainfield renewed worries of anti-Muslim discrimination in the Chicago area's large and established Palestinian community. The proceedings also come amid rising hostility against Muslims and Palestinians in the United States since Hamas attacked Israel in October 2023. Hundreds attended the boy's janazah, or funeral service, where the boy was remembered as kind and into sports and Legos. In January, Shaheen met with then-President Joe Biden. Separately, the father of the boy, who was divorced from Shaheen and did not live at the home, has filed a wrongful death lawsuit. He attended the court proceedings Tuesday along with an uncle. Shaheen, who has also filed another civil lawsuit, has retained prominent civil rights attorney Ben Crump. He said Shaheen would not talk to reporters during the trial, which is expected to last about a week. Hanan Shaheen continues the unimaginable fight for justice for Wadi. He said in a statement, "We have confidence in the prosecution's efforts to earn justice for Wadi and Hanan." This is 71-year-old Joseph Suba, ladies and gentlemen. And I'm trying to actually see what justice would look like for him. He's 71 years of age. If he's convicted, one, how long will it be for? And two, how long will it last? Because let me reiterate once again, he is 71 years of age. If I were to take a hazard of prediction, I would say at best, I would give him about 10, 15, maybe 20 years, depending on his health. But that's all I give. Yes, I understand the seriousness of the crime, and I believe in the old adage: don't do the crime if you can't do the time. But how long would he last behind bars? What would justice truly look like in Joseph Zuba's case? Next up we have an update on the Adnan Syed case. He's seeking a reduced sentence and still will remain a convicted murderer despite evidence problems and requests to clear his record. Despite documented problems with the evidence against him and an earlier request from prosecutors to clear his record, Adnan Syed will remain a convicted murderer, according to court papers filed. The decision from Baltimore prosecutors ahead of a scheduled hearing where a judge will consider whether to reduce Syed's sentence, but this means the conviction itself is no longer in question. It's the latest wrinkle in an ongoing legal odyssey that garnered a massive following after being featured in the Serial podcast over a decade ago. Syed's attorneys recently filed the request for a sentence reduction under Maryland's Juvenile Restoration Act, a relatively new state law that provides a potential pathway to release for people serving long prison terms and crimes committed when they were minors. That request is supported by prosecutors. Meanwhile, Baltimore State's Attorney Ivan Bates announced that his office is withdrawing a previously filed motion to vacate Syed's conviction in the 1999 killing of his high school ex-girlfriend, Hai-Min Lee, who was found strangled to death and buried in a makeshift grave. I did not make this decision lightly, but it is necessary to preserve the credibility of our office and maintain public trust in the justice system, he says in a statement. The original motion to vacate, which was filed by Bates' predecessor, Marilyn Mosby, won Syed his freedom in 2022, but his conviction was reinstated following a procedural challenge from Lee's family. The Maryland Supreme Court ordered a redo of the conviction vacatur hearing after finding that the family didn't receive adequate notice to attend in person. Since the prosecutor's office changed hands in the meantime, the decision of whether to withdraw the motion fell to Bates. Instead of asking the judge again to consider Syed's guilt or innocence, Bates chose a different path. He supported Syed's motion for a reduced sentence without addressing the underlying conviction. Bates says that since his release in 2022, Syed has demonstrated he is a productive member of society whose continued freedom is in the interest of justice. He said the case is precisely what legislators envisioned when they crafted the Juvenile Restoration Act. The legislation was passed amid growing consensus that such defendants are especially open to rehabilitation, partly because brain science shows cognitive development continues well beyond the teenage years. Syed was 17 when Lee was killed. Now 43, he has been working at Georgetown University's Prisons and Justice Initiative and caring for aging relatives since his release, according to court findings. His father died in October after a long illness. Bates was facing a deadline to decide on the motion to vacate. After reviewing the motion filed by his predecessor, Bates concluded that it contained false and misleading statements that undermine the integrity of the judicial process, he said in the statement. Bates wrote in an executive summary that his decision does not preclude Mr. Syed from raising any new issues that he believes will support his innocence in the proper post-trial pleadings. However, properly shifting this burden back to Mr. Syed will reinstill the adversarial nature of proceedings that are the hallmark of the truth-seeking function of our criminal justice system, the summary says. Attorneys for the victim's family had argued that prosecutors should address the integrity of Syed's conviction before the court considered reducing his sentence. Prosecutors should not be allowed to duck the issue by hiding behind his motion for a reduced sentence. Attorneys wrote. That's what the attorneys wrote in a recent filing. Syed has maintained his innocence from the beginning, but many questions remain unanswered even after the serial podcast combed through the evidence, re-examined legal arguments, and interviewed witnesses. The series debuted in 2014 and drew millions of listeners who became armchair detectives. Rife with legal twists and turns, the case has recently pitted criminal justice reform efforts against the rights of the crime victims and their families, whose votes are often at odds with a growing movement to acknowledge and correct systemic racism, police misconduct, and prosecutorial missteps. When prosecutors sought to vacate Syed's conviction in 2022, they cited numerous problems with the case, including alternative suspects and unreliable evidence presented at trial. A judge agreed to vacate the conviction and free Syed. Prosecutors in Mosby's office later chose not to refile charges after they said DNA testing excluded Syed as a suspect. Even though the appellate courts reinstated his conviction, they allowed Syed to remain free while the case continued. And it is going right now. We won't know until we know for certain. He stands convicted, but he still walks free. Next up, this one is a good thing. I do have the trigger warning on. It's a good thing. An American teen is accused of throwing an infant out of a Paris hotel window. This teen was on their gap year trip. The child was found wrapped in a cloth with their umbilical cord still attached, according to police. So if this is the kind of case that's gonna mess with your mental health, and I am a proponent of protecting your mental health. So if this case is gonna rattle your nerves, then I suggest you skip this particular story. Okay. Now that you've been warned, this is the shot of the Ibis Styles Hotel in Paris, France. Okay. The American teen who was arrested in Paris after she allegedly threw a newborn out of a hotel window was in France as part of a gap year program. The 18-year-old, who has not been publicly named, is accused of throwing the newborn from a second-floor window of a Paris hotel on Monday, February 24th. The newborn was taken to a hospital but did not survive, according to the prosecution's office in a statement, adding that it had opened an investigation into a homicide of a minor. The woman was reportedly on a trip through a Massachusetts-based international cultural program, according to a report from the Associated Press. EF Gap Year, which coordinates international educational programs across 12 countries, including Switzerland, Italy, and France, confirmed to the Associated Press that the teenager was in France as part of their cohort. We are deeply shocked and saddened by this tragic event, and our thoughts are with everyone affected during this difficult time, the organization said in an emailed statement to the Associated Press. Details surrounding the circumstances of this incident are sparse. The infant was reportedly attached to its umbilical cord and wrapped in a cloth when it was found. That's according to Barron, citing local police. The body was found after it had been moved to a trash can nearby, according to a report from CNN citing authorities. The U.S. Embassy in Paris did not immediately respond to people's requests for comments, but told CNN they are monitoring the case. We are deeply saddened to learn of the recent tragedy involving the loss of a young life, the embassy told the outlet. Where do I begin with this one? Okay, let's assume this was this 18-year-old's child. If you were that scared, give the child to someone that would care for her or him. I don't know how many different times I can bring myself to say those words. But give the child to someone that's going to care for it. I don't care if it's just a newborn child. You don't want it? No problem. But give it to somebody that will love that child, that will take care of that child. Give that child a chance to grow, become something. This is the kind of case that hurts my heart. I know you're supposed to be on your gap year trip to France, and I get that. But you also you're a college student. You gotta be a little wiser than that. Anything less is just downright cruel. And what that was? That was cruelty to the nth degree. Next up. A Florida single mother of two identified as a road rage shooting victim. Georgianne Park Garner was celebrating her 48th birthday on February 22nd with her daughter, 19-year-old Marilee Davis, when they were victims in a road rage shooting. It was said that Georgianne Park Garner still had so much life to live. And from the look on this picture, it looked like she really did have a lot of life left. A single mother was fatally shot in front of her daughter during a road rage incident in Panama City, Florida on Saturday, February 22nd, according to a news release from the Panama City Police Department. Georgianne Park Garner was celebrating her 48th birthday and Mardi Gras with her daughter, Marilee Lewis, age 19, when they were engaged in a road rage incident with Jubal Simmons, age 23, and Ivy Bella Encino, age 21. Encino and Simmons allegedly became angry over a traffic dispute and verbally harassed Garner and Lewis. The incident allegedly escalated into a brief physical altercation between Lewis and Encino before both parties separated and returned to their vehicles, police said. Simmons allegedly shot the mother and daughter 11 times, striking Garner and Lewis in the chest and hitting an uninvolved vehicle, according to the PCPD. The two other occupants in Garner's vehicle were unharmed. Encino was the suspect driving the Dodge Ram that drove away from Garner's car. Garner and the occupants of her vehicle did not have a prior connection to Simmons or Encino, according to detectives. And here's our defendants: Jubal Simmons on your left, Ivy Bella Encino on your right. PCPD officers responded to calls around 4:15 p.m. and one nearby officer chased Encino's car, which had fled the scene. Encino then rammed a PCPD patrol unit, disabling both vehicles. She was taken into custody without further incident, per the PCPD. Encino was charged with accessory to murder, aggravated battery on a law enforcement officer, aggravated fleeing and eluding law enforcement, and driving while license was suspended or revoked. Simmons fled on foot but was taken into custody a short distance away. He was charged with murder, 3 counts of attempted murder, 2 counts of firing into an occupied vehicle, discharging a firearm from a vehicle, tampering with evidence, and resisting officers without violence. Once officers arrived at the scene, Garner and Lewis were both suffering from gunshot wounds, and nearby witnesses administered first aid before EMS arrived. The victims were transported to a local hospital. Shortly after their arrival, Garner succumbed to her injuries. Lewis is still in the ICU, according to a GoFundMe. She remains on a ventilator and is fighting for her life and still has a long recovery. This according to the GoFundMe created by Garner's friend Sandra Peterson. The donation page was created to raise funds for medical bills, funeral expenses, and legal assistance. The world lost a beautiful soul that day. Georgianne truly had a smile that would light up a room. Her eyes twinkled when she laughed and glittered when she snorted. She was taken from us far too quickly, the GoFundMe description read of Garner, a single mom to Lewis and son Davin. She still had so much life to live. Apparently this case is still open, so anyone with additional information, you are urged to contact the Panama City Police Department. That number is 850-872-3100. 850-872-3100. Anonymous tips can also be submitted through Crime Stoppers. That number is 850-785-TIPS. 850-785-8477. A representative for the Panama City Police Department did not immediately respond to People Magazine's request for more information. It burns me. It kills me. I read a lot of these road rage stories, and all I hear is the same thing. Apparently a driver didn't get what they wanted, so they're gonna take it out on yet another driver. And usually it ends in violence. Why? Why? It's not like you own the road or anything. Oh, but then again, when you're dealing with road rage, telling them that is going to set it off even more. Or maybe it's because they have that. It's that entitled Karen mentality mixed with anger, add car, add road, add other drivers, and mix and set fire to it. That's my description of road rage. That's my take on what road rage is. Okay. We're going to go back to the courtroom for The verdict in the Bedtime murder trial, Florida versus Jermaine Bass. He's standing trial on charges after that he shot his two children, his 5-year-old daughter and 8-year-old son, killing the daughter. All right, it's day 4 of the trial, and here we go again. 32-year-old Jermaine Bass charged with first-degree murder, attempted murder, and 2 counts of aggravated child abuse for the shooting that killed his daughter, 5-year-old Jayla Bass, and injured his 8-year-old son. We're gonna go to court, and we're gonna go get the verdict in that case right now.
Evidence, discussed it fully with the other jurors, and listen to the views of your fellow jurors. Do not hesitate to change your opinion if the discussion persuades. All right, the verdict form is in order. If you would publish the verdict and pull the jury, please.
Yes, ma'am. State of Florida versus Jermaine LaVonda Bass. Case number 22 CF 011717A, Trial Division 3, verdict form. We, the jury, find as follows as to count 1, murder in the first degree. The defendant is guilty of murder in the first degree, Jayla Bass, as charged. And during the commission of the offense, did the defendant personally carry, display, use, threaten, or attempt to use any weapon or firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge the firearm? Yes. Did the discharge cause death of the victim? Yes. 12 of the 12 of us find the killing was premeditated murder. 12 of the 12 of us find the killing was premeditated murder and felony murder. We, the jury, find as follows as to count 2, aggravated child abuse. The defendant is guilty of aggravated child abuse as charged. We, the jury, find as follows as to count 3, aggravated child abuse. Jermaine J.J. Bass. The defendant is guilty of aggravated child abuse as charged. We, the jury, find as follows as to count 4, attempted murder in the first degree, Jermaine J.J. Bass. The defendant is guilty of attempted murder in the first degree, Jermaine J.J. Bass, as charged. And during the commission of the offense, did the defendant personally carry, display, use, threaten, or attempt to use any weapon or firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge the firearm? Yes. Did the discharge cause great bodily harm to the victim? Yes. So say we all, dated this 27th day of February 2025, juror number 1, foreperson of the jury. Juror number 1, are these your true and correct verdicts? Yeah. Juror number 2, are these your true and correct verdicts? Yeah. Juror number 3, are these your true and correct verdicts? Juror number 4, are these your true and correct verdicts? They are. Juror number 5, are these your true and correct verdicts? They are. Juror number 6, are these your true and correct verdicts? They are. Juror number 8, are these your true and correct verdicts? They are. Juror number 9, are these your true and correct verdicts? They are. Juror number 10, are these your true and correct verdicts? They are. Juror number 12, are these your true and correct verdicts? They are. Juror number 14, are these your true and correct verdicts? Yes. Thank you. I can't see.
You missed one.
I was 12. You missed one.
You missed 11.
11, excuse me. Juror number 11, are these your true and correct verdicts?
Yes, they are.
Thank you.
And juror number 12, are these your true and correct verdicts?
I can't.
Yes?
Yes.
Okay, thank
Okay,
you.
thank you.
All right, ladies and gentlemen, I know that you have spent a considerable amount of time and effort today deliberating on this case, and I cannot thank you enough for that, as well as your patience and with us and hard work all week. As you've now seen, it is why we need people like you who respond down with the jury service summons to handle the cases and the disputes that the parties cannot resolve among themselves. So you are essential and a true backbone to our system of justice, and I cannot tell you how much you are appreciated by me personally, as well as all of the judges here in Tampa, Hillsborough County. That much being said, all of my constant admonitions about not talking about the case are obviously lifted. You can do as much speaking about the case as you would like to, or discussion or investigation or whatever you'd like to know in addition to what you've heard during the course of this trial. I do hope if you share your trial experience with others, it does have a somewhat positive spin, so that when they get a jury service summons, they too will come down to the courthouse, as you all have this week, to serve the citizens of Hillsborough as you all have. I spent a considerable amount of time as a trial lawyer before I became a judge. I loved to talk to jurors after cases to see how the presentation went and what questions jurors had or didn't have, or just talk about deliberations in general. That option is open to you. Of course, you're not required to do that, but if you wanted to talk to any of the lawyers, or if you have any feedback for me, let the bailiffs know, and they'll tell you not only you have my contact information, you're welcome to get back in contact with me, or if you want to come back in and speak to any of the lawyers about their cases, you're welcome to do that as well. But officially, your jury service is concluded with the thanks of both parties, and with the thanks of all of my colleagues, the judges here in Tampa, Florida. So thank you very much for your service. Maybe we will see you down here next time you get a jury service summons, but thank you for all of your efforts this week. Have a great rest of your week and weekend.
All rise.
All right, have a seat. Any reason not to proceed with sentencing at this time?
Well, Judge, yes, we'll be filing motions, and also there would need to be a score sheet for the other counts, so I would request sentencing be set off.
All right,
And I also need to discuss that very briefly as well with Mr. Bass about a PSI.
all right, sure.
That's fine, Judge. I had not prepared a score sheet. Obviously, I didn't know what verdict would be or what if it could be lesser, so I just didn't have anything prepared. But and I know, Judge, in speaking with the family, I believe at least one of them would like to say something. So I know if we can just maybe have another date.
All right.
And I'm gonna freeze it right there. You've heard it. You heard everything you need to hear. Jermaine Bass found guilty. Found guilty of first-degree murder, attempted murder, and 2 counts of aggravated child abuse. We will find out. Sentencing has been deferred so that a pre-sentencing investigation can be done. But the bottom line is, right now, Jermaine Bass is a convicted murderer of his 5-year-old daughter Jayla, a convicted attempted murderer of his 8-year-old son JJ. When we get word about when sentencing will take place for Bass, you'll hear it right here first. Ooh, this is an exclusive, guys. We covered the Ruby Frankie case. Now, in an interview with Good Morning America, Kevin and Chad Frankie said everything changed in their household once Ruby hired Jody Hildebrand. Ruby Frankie's estranged husband is speaking out for the first time since the vlogger pleaded guilty to child abuse. Kevin Frankie, who has since filed for divorce from Ruby, spoke to Good Morning America alongside the couple's oldest son, Chad Frankie, ahead of their upcoming Hulu docuseries titled Devil in the Family, The Fall of Ruby Frankie. Last year, Ruby and her business partner, Jody Hildebrand, were given 4 consecutive sentences of 1 to 15 years in prison for 4 counts of aggravated child abuse. Ruby and Hildebrand were arrested after the Frankie's youngest son escaped Hildebrand's home and knocked on the door of a neighbor asking for food and water. The neighbor noticed duct tape on the child's ankles and wrists and called police, according to court documents. Police later found one of the Frankie's daughters emaciated inside Hildebrand's home. As part of the agreement, Ruby admitted to isolating her son, binding his hands and feet with rope, and forcing him to do physical labor in the sun for hours without food and water. As part of her plea agreement, Hildebrand admitted to coercing the Frankie's 9-year-old daughter to jump into a cactus multiple times and helping Ruby physically and mentally torture her youngest son. In their interview with GMA, Kevin and Chad said everything changed in their household once Ruby hired Hildebrand, a therapist and life coach. Kevin said Hildebrand came across as someone who was firm and very authoritative, but was shocked when Hildebrand's focus turned to Kevin and Ruby's marriage. Chad said, "Looking back, I treated Hildebrand as a god, and I trusted her so much." Hildebrand insisted Kevin move out of the family's home and cut off contact to work on his addiction to selfishness. That's according to a report from GMA. When asked how he could leave his family, Kevin said, "The bottom line was I was choosing to trust a licensed professional mental health counselor and my wife, and they gave terrible counsel." Kevin says he still loves Ruby. However, he doesn't want her involved in their lives. He then warned of the dangers of putting yourself and your family on social media and exercising caution with who you trust. And to that I say, finally, Kevin Frankie is woken up. Whew. If there's anybody I wouldn't trust with my kids, my marriage, it's somebody who calls themselves what was it again? A licensed professional mental health counselor. If it comes down to my kids, there's only two people I trust. My wife and me. When it comes down to our marriage, there's only 2 people I trust with that. My wife and me. If I put my trust in anybody else regarding my marriage or my kids, I'm in trouble. My wife is in trouble. Because we don't have that strong relationship we claim to have. And that is where, in my opinion, Kevin Frankie failed. That's where he failed. Trusting his wife is one thing, but he trusted the counsel of Jody Hildebrand, and right now he's paying a very steep price. I just hope he can recover. And as far as the kids go, I hope and pray that they're doing a lot better than what they were doing. Next up, Donna Adelson took a stand at a pretrial hearing as she fights to be released from jail and for the recorded phone calls to be suppressed. Donna Adelson is describing her life behind bars. She took the stand twice at a pretrial hearing, breaking down and crying and shaking on the stand as she detailed her life in jail. Adelson is charged with masterminding the murder for hire of her former son-in-law, FSU professor Dan Markle, who was shot and killed in his driveway in 2014. Adelson's son Charlie has already been convicted for his role in the plot, along with Charlie's ex-girlfriend, Catherine Magbanua, and two other men. Donna has been in custody since her arrest in November 2023 and described moving through phases of protective custody and living in an annex with 65 other women. During her period in the annex, Donna said she was assaulted multiple times. The first time in the shower. All of a sudden I felt a hand go up my back from the top of my butt up my back. Donna, who began to cry while recounting the tale, said when she screamed, the inmate ran away. Another assault allegedly occurred while Donna was brushing her teeth and led to ongoing extortion. Donna said that another inmate told her, unless you want those pretty white teeth knocked out of your mouth, you're going to buy me commissary. Donna said she complied and refused to name the inmate, describing her only as a big woman out of fear. One thing I've learned since I'm there, Donna said, you don't snitch. You don't tell on anyone. Police moved in to arrest Donna while she was on the jetway to board a flight with a one-way ticket to Vietnam. When asked about that, Donna denied trying to leave the country in an attempt to escape criminal charges and insisted she was looking to get away for some peace following her son's conviction. Donna also detailed her other medical issues she's faced behind bars, including sciatica and earwax buildup, as she fights to be released on bond pending her trial, currently scheduled to begin in June. Her defense pointed to inadequate medical care for a cut that resulted in her stemming the bleeding using sanitary pads. At the hearing, Donna and her attorneys asked the judge to suppress a recording following a phone call Donna had with Charlie in November 2023. At the end of that call, Charlie was disconnected, unbeknownst to Donna. Donna continued talking, and even after realizing Charlie was no longer connected, had conversations with others in the room with her. The phone was never properly hung up and continued recording. Describing the call from the witness stand, Donna said, all of a sudden I asked him something, and I said, Charlie, do you hear me? Charlie? I said it a few times, but he didn't respond anymore. The call was over. Donna said that disconnections are nothing new. It happens a lot, unfortunately. Donna acknowledged the warning before the jail call that she would be recorded, but she maintained the call was over while the recording kept going. It ended when Charlie hung up. However, prosecutors said Donna should have known the call was still being recorded and that her failure to hang up the phone properly didn't impact the admissibility of the call. The state did not intend to record the conversation in her home, and the fact that she was recorded was not caused by the state's actions. It was caused by the defendant's actions. The judge reserved ruling on the motions. Donna. You're sitting in a jail cell at the moment, and you're forgetting the one thing they told you when they read you your Miranda rights. I'm gonna come into the camera just a little bit closer. Just give me long enough to get there, right? All right. Let me remind you, and everybody within eye shot of my face and earshot of my voice, when you're arrested, whether you're a guest of the state, they always give you the same speech time and time again. You have the right to remain silent. Anything you say can and will be held against you in a court of law. That is the biggest truth you should know while you're either in jail waiting on your trial, whether you're in prison while you're serving an extended length of time, or you're just in jail waiting on your arraignment. The bottom line is that key phrase. Anything, bold, italicized, and triple underline. Anything you say can and will be held against not the state, not your witness, but held against you. Period. Just a little food for thought, Donna. Next up, Lyle and Eric Menendez's attorneys say Governor Gavin Newsom has asked the state parole board to investigate if they pose a risk if they were freed. I'm gonna give you part of this this article, and then I'm gonna take you right to the press conference with the family of the Menendez brothers. Attorneys for Lyle and Eric Menendez said that California Governor Gavin Newsom has ordered the state parole board to investigate whether the brothers will pose a risk to the public if they are released after nearly 3 decades in prison for the 1989 killing of their parents. The board will undertake a comprehensive risk assessment into whether the brothers have been rehabilitated, according to Mark Garagos and Cliff Gardner. The defense attorneys said they were grateful for Newsom's decision. The family realizes that the governor's action does not mean he will commute the sentences. Instead, this initial step reflects the governor's considered decision to at least obtain information required to make a fair decision as to whether Eric and Lyle, after 35 years in prison, have done the hard work necessary to have a chance at a life outside of prison, Garagos and Gardner said in a statement. No timeline was given for the board's investigation. A message seeking further details was sent to the governor's office. The brothers are pursuing multiple avenues to win their freedom: clemency from Newsom, a resentencing hearing, and a new trial. Los Angeles District Attorney Nathan Hackman said that he opposes a new trial for the brothers, but he hasn't made up his mind on whether to support a resentencing bid that could lead to their freedom. Newsom has said he will not make a clemency decision until Hackman finishes reviewing the case. The brothers were found guilty in the murders of their entertainment executive father Jose and their mother Kitty Menendez and sentenced to life in prison without parole. They began their latest bid for freedom in recent years after their attorneys said new evidence of their father's sexual abuse emerged, and they have the support of most of their extended family. Hackman said he has filed for an informal response urging the LA County Superior Court to reject a habeas petition filed by the brothers' attorneys in 2023 that seeks a re-examination of their case that centers in part of the allegations that Jose Menendez sexually abused Eric Menendez. Okay, let's go to the courtroom for the Menendez brothers family press conference.
All right, I'm going to kick us off. I am going to start recording.
Recording in progress.
I started recording the session. Thank you all for joining. The format of today's press conference is Tamara Goodell and Anna Maria Baralt are going to share some remarks with you. And then at the very end, we're going to take time for questions. You can submit your questions in the chat. Or raise your hand and I will call on you as we can. Thank you very much. And with that, I'm going to turn it over to our speakers.
Hi, everyone. Thank you for joining us today. My name is Anna Maria Baralt, and I am currently in my home office. So that means we are going to hope that Amazon does not decide to deliver to my house within the next 45 minutes or so, or you're going to hear my dogs lose their minds. So with that, I do have some remarks. This is a pretty exciting time for us as the family of Eric and Lyle Menendez. And I'd like to start with Governor Newsom's actions yesterday. They are a positive step forward towards Eric and Lyle's release. We are incredibly grateful that Governor Newsom is paying attention to this case, particularly those of us, those older family members, my mother, Terry Baralt, Joan Vandermolen, Kitty's sister. This is for our family. It is a huge sigh of relief that someone in a seat of power is paying attention to what we have seen up close since Eric and Lyle have been incarcerated. We have seen their rehabilitation over the last 3 decades with no hope of release until now. Eric and Lyle have changed countless lives since their conviction in 1996. Inmates have seen it, corrections officers have seen it, and now we need the entire criminal justice system to see it. The resentencing process has been a long journey for us. Now with the new directive to the parole board, we are confident that they will determine the brothers are not a risk to public safety, proving what we have said all along. Important in this process is that this is not a political one. We look forward to their transparency and for the findings that will be released for everyone to see. Now let's take a look at the criteria the parole board will look at. Number 1 is remorse. Eric and Lyle have expressed immense remorse for their actions that night and in the months after, repeatedly. Decade after decade, I can personally attest to that. They look at number 2 is social history. Inmates, corrections officers, and administrators have all gone on record to say Eric and Lyle have been model people while incarcerated. They have run several programs to mentor inmates who they knew would see the freedom that they wouldn't. That is remarkable. Third, plans for the future. The parole board will look at their plans for the future. And Eric and Lyle have already done so much tangible good work while incarcerated for society. If released, they will continue to build on the work they've started. They'll look at institutional behavior. everything I've just touched on shows that they have gone above and beyond to not only function within the walls of a prison, but improve the culture of that facility through their work. They have improved the community that surrounds them. And then they'll look at their age. You know, Eric and Lyle are both in their 50s. We all are. They have spent the majority of their lives incarcerated. And incredibly, they've managed to build meaningful lives year after year, program after program. And then they'll look at their lack of criminal history. They don't have a prior criminal record outside of making a horrific decision as a direct result of the abuse they endured for over a decade. The parole board must also factor in the fact that Eric and Lyle were still kids at the time of their actions. So Lyle was 21 and Eric was 18 at the time of the killings. There is overwhelming scientific research that proves the human brain, especially areas that regulate impulse control and decision-making, is not fully developed until someone is in their mid-20s. As the mother of a 17 and 18-year-old boys, I can attest to that as well. Both the legislature and the courts have recognized that youthful offenders have diminished moral culpability and a greater capacity for rehabilitation based on widely accepted scientific evidence on adolescent brain development. They must take that into consideration. I'll pass it over to Tamara.
Thanks, Anna Maria. I just really want to go over everything that they have done since they were convicted in 1996. I think it's incredibly important to stress that Eric and Lyle went into prison, into incarceration during their formative years and have, for all intents and purposes, created careers for themselves while they have been incarcerated. And that is incredibly moving for all of us. While incarcerated, Eric has created and led several impactful programs, which I will detail now. The Life Care and Hospice Connections program, which is an ADA awareness and support group assisting disabled and elderly inmates while educating others about the challenges faced by less able peers. The Victim Impact and Empathy program, or VIVE, is a workshop fostering understanding and empathy by incorporating victim impact elements from the life care and hospice curriculum. Alternatives to Violence Project, AVP, is a series of workshops promoting nonviolent conflict resolution, self-awareness, empathy, and community building. The Starlight Peace Project is a program capturing images of peace in areas affected by violence. It has successfully coordinated 30 event leaders and engaged over 150 participants. Eric has also led 12-step and meditation classes. This combines the 12 steps of Alcoholics Anonymous and Narcotics Anonymous with mindfulness, meditation, and meditation practices. Insight meditation workshops, which introduces inmates to the physical, emotional, and spiritual benefits of mindfulness meditation. Eric has received dozens of commendations from prison supervisors for his leadership, mentorship, and his service to fellow inmates, which are all detailed in the People's Motion requesting 1172.1, recall of sentence and resentencing hearing. And with that, I will let Anne Maria go into Lyle's details of rehabilitation.
Thanks, Tamara. Lyle has also made significant contributions, creating and leading impactful programs. The Adverse Childhood Experience in Rehabilitation, ACER program, is a program helping offenders explore their childhood experiences and impact and contributions to criminal behavior. The Green Space Project spearheaded the beautification of prison spaces through murals and landscaping, reducing recidivism by normalizing the prison environment. Over 100 inmates participated, marking the first time prison administration entrusted an inmate to lead such a redesign. The Rehabilitation Through Beautification Project, RTB, a volunteer effort supporting the Green Space Project through mural painting and landscaping. The Youth LWAP Ally, a mentoring group for youth offenders with life without parole sentences, guiding others in their rehabilitation journeys. And the Wire Bulletin, an inmate advisory bulletin fostering communication between the Inmate Advisory Council to the wider inmate population. Their achievements, both Eric and Lyle, would be inspiring for anyone, but as incarcerated individuals, they are truly amazing. And now I want to talk about the narratives painted by the district attorney at the press conference, which closely illustrated those presented at the first trial. First, no one is disputing the crime, not even Eric and Lyle. All we are asking for is the DA to consider their prison record as a whole, their rehabilitation, the remorse they have expressed, and the new evidence the habeas petition introduces, which corroborates Eric and Lyle's story. While we are not surprised that the district attorney took the stance that he did with the habeas petition, we were surprised to see it litigated the way that it was in the press, with the press. The danger of presenting that 1990s narrative under today's laws and modern understanding of trauma is that it ignores how far we have come in recognizing the long-term effects of abuse and the systemic barriers that keep victims silent. Today, we understand that trauma rewires the brain and shapes a person's actions and decisions in ways that were not fully appreciated decades ago. California law has evolved to reflect this, acknowledging that childhood abuse profoundly impacts behavior and should be a critical factor in the justice system. It's not just about speaking out, because for many survivors, that is an impossible task. The very act of acknowledging their trauma can take years, sometimes a lifetime. The expectation that victims should have immediately disclosed their abuse ignores the reality of trauma. Many survivors struggle with self-blame, fear, and shame, all of which are exacerbated by a system that has historically dismissed their voices. While we acknowledge that the district attorney has a duty to prosecute cases based on the law, we must ask, is he applying the law as it exists today with a modern trauma-informed understanding? Or is he relying on an outdated, harmful framework that has since been rejected? While we don't want to focus too much more on his comments on the habeas petition, we do want to take a moment and address his comments on the letter Eric sent to Andy and Roy Rosello's testimony. Andy received the letter in December of 1988. The time for proving the authenticity of the letter will be discussed in court. But what we can say now is that Andy was a teenage boy at the time. He was 15, by the way. Actually, I think he was still 14. With all of the mounds of evidence presented in the first trial, it's only natural for a teenage boy to not realize he is sitting on critical evidence. Andy wasn't a lawyer. He wasn't even an adult. To pose the question now, decades later after he passed, of why wasn't the letter submitted back then, is like asking a teenager who got an offender bender, why didn't you call the police to file a report? Because a teenager doesn't know any better. He didn't realize how vital that letter would be to the case. Second, he indicated that Roy Rosello's testimony doesn't meet the habeas standards because he didn't come forward sooner. The whole point of a habeas petition is to include new evidence, and Roy coming out to share his story in his own time is new evidence. Again, how many victims have stayed silent because of the systems that are designed to silence and dismiss them? Let's bring the case back to 2025. Tamara.
Thanks again. It is also critically relevant to discuss the fact that California law increasingly acknowledges that youthfulness impacts decision-making, often leading young people to have irrationally or dishonestly in stressful and traumatic circumstances. Such youthful missteps should not overshadow or negate subsequent truthful disclosures. We, including California state law and every clinical psychologist, now understand that trauma, especially at a young age, can rewire someone's brain. The trauma, like Eric and Lyle endured, cripples victims' ability to think rationally before, during, and after taking action. Today, there's overwhelming evidence of adverse childhood experiences, or ACEs, which show that early exposure to severe abuse fundamentally alters a person's mental and emotional behavior. If Eric and Lyle were tried today, California law would have compelled Hackman's office to consider the abuse that molded every fiber of their being. But Eric and Lyle are not kids anymore. They are grown men who have transformed their lives while incarcerated. We wish the DA had spoken about the programs that they have spearheaded, the support groups that they have started, the higher learning that they have pursued, and the numerous other inmates that they have inspired. Through their work, Eric and Lyle have shown who they really are, not who Jose and Kitty made them. They did all of this while fully knowing it may not mean a release for them, but a difference for those with whom they have served time. Eric and Lyle have dedicated themselves to extensive rehabilitation, education, and service during their incarceration, earning widespread admiration from peers and prison staff. And it's so important to emphasize that all of these actions and rehabilitation activities that they have completed were all done without any hope of being released. And then with that, I'll let Anna Maria talk about more growth and leadership.
I need to unmute myself. Eric and Lyle's remarkable growth, leadership, and rehabilitation efforts underscore their readiness to lead meaningful and productive lives outside of prison. Let's keep focusing on this. For our family, it has been 3 painful decades. We have been forced to live through the trauma every day since August 20th, 1989. We have become victims in this process. We have been laughed at, ridiculed, and forced to relive the pain over and over again. We ask that people visit our coalition page at justiceforericandlyle.org and sign the petition that's there. Thank you so much for your time. We'll open it up for questions.
Again, as a reminder, please either raise your hand or submit your question to in the Q&A box that is at the bottom of the screen, and we will answer your questions. 1 second. Tim, you have the floor.
Great, just unmuted. I hope you can hear me.
Yes.
So thank you very much for doing that. I was wondering if each of you could reflect a little
Tim,
more.
you're actually a little muffled.
How's that?
Much better.
Okay. I was wondering if each of you could reflect a little bit on their evolution in prison. And what I'm trying to get at is, was there like a specific turning point for each where they were at a crossroads and they decided to go in the direction of trying to turn their lives around? Because I imagine they didn't walk in the first day of their sentence and they're doing all these wonderful things. So I was wondering, was there a crossroads or a turning point where they went in that direction? If you could talk a little bit about that.
I'll take this first. I don't know that I can put a date. I can timestamp that. For sure, Tim, you're right that there was those early years in level 4 maximum security were rough. were rough for them. Their experiences were rough. They were finding themselves as adults, never mind. They were adolescents when they went into prison. So that was a tough evolution for them. I can tell you that I remember a moment in 2006. So this is now almost 20 years ago, when I was communicating with Lyle, and he sent me a letter that I will never forget, because it felt different. It felt, he said, and this is sort of burned in my memory, so I know it by heart. And he said, "I need you to understand that I recognize my actions are your personal tragedy, and that I know I can never take it back, but I will spend the rest of my life trying to make it better." And it was so stunning to me. I had seen him growing, but it was for me, it marked, like, this was a man who was taking complete ownership, complete accountability. And it's really been a beautiful thing to see their journeys.
I think just to add to that, in conversations with Eric, it's been not, to your same point, that wasn't necessarily one date. It was the result of a combination of experiences and the witnessing of some very violent interactions within the prison system. And Eric made a very conscious decision to understand that he had to make the most of where he was, and made some decisions based on what he was seeing around him, and whether it was regarding poor prison conditions or poor treatment of inmates, he really wanted to work towards, how can I create a better place, not just for myself where I can exist, but how can I also affect those positively with those around me.
Thank you both. I'm going to call on Matt next. Matt, you have the floor.
Hi, folks. Thanks for taking this, and thank you for doing this press conference. I would just like to hear your reactions to Gavin Newsom's announcement yesterday that he is setting up this risk assessment investigation into whether the brothers would pose a risk if they were released, because in many ways that circumvents LADA Nathan Hackman's decision on resentencing. I mean, almost effectively it sets resentencing in motion, and I wanted to get your impressions when you first heard that news.
I'll take this. I was thrilled. First of all, I had a meeting with some of the members of the governor's office on Monday, where I was told, it was thrilling. Although it was the beginning of the meeting was, we're not granting clemency, so keep your expectations in check. I was like, okay, but we are taking this step, and we are providing risk assessment. And it was, there were definitely some caveats, like there are no guarantees. So remember that, this is not a guaranteed process. This is a very rigorous process that we are going to go through, because it is very important to California that they have a low recidivism rate. So they will be doing a very rigorous and full process with it. But this is huge. I mean, this is huge. And I cannot thank Governor Newsom enough for stepping in and initiating this process. We as a family, we understand that this is not without professional risk for him. So for him to step in and say, okay, let's actually find out if this is doable. Let's do a risk analysis, and then we can move forward. It's a huge relief. It's a huge relief to us.
Anna Marie, I have to ask you, can you take us into that room in that moment? Were there audible gasps Were people, sort of like high-fiving? What was that mood like, and how did you and the people with you react?
Well, it was a very small group of people, like 3 people. And it was virtual. So I would have been high-fiving the air. And so I couldn't be high-fiving. I certainly gasped in relief. And it was, that was great news. Yeah.
Thank you.
Great. Veronica, I'm going to call on you next.
Hi there. Can you hear me okay? Thank you so much for calling on me. So I'm curious about the relationship that you have with District Attorney Nathan Hackman, seemingly very different than the relationship that you have with the former DA George Gascon. Can you comment on the decision to not recommend a retrial? Have you spoken with him? If not, do you have a message for Nathan Hackman?
Jomi, the relationship is absolutely different. Gascon seemed much more open to modern thought processes of, where is the law today? What does compassionate look like? And what does trauma-informed practice look like? Very honestly, what we heard from the LADA's office the other day felt very disparaging. It felt like a continuation of the narrative from 1989. And very honestly, it was very frustrating. There have been so many developments that could have been brought into focus. And it was incredibly disappointing to hear that there was no mention of the rehabilitation, no mention of the positive contributions that Eric and Lyle have made to the prison system. And I say system because they have been in multiple facilities, each of them. So it's really important to recognize that and to know that they have had so many recognitions and commendations from the officers, and that went unnoticed by him, or at least he made it seem that way. So it was very, very disappointing, in my honest opinion. So, Anna Marie, I'll let you speak to
that. Well, first of all, we, with the last administration, we worked with Brock and Nancy, were the ones who headed up that resentencing group, and that they were tremendous. They were really supportive, and they were very well informed about trauma. I think the press conference with the district attorney last Friday it felt extra hurtful because it was only a few weeks ago that dozens of us sat in his office and described to him the horror of being in this victim's family, with 35 years of being re-traumatized over and over and over. With my 85-year-old mother with cancer sitting 10 feet away from him, literally sobbing in front of him. And then to see him decide to go make a press conference that didn't have to be a press conference, and just in gruesome detail and even a little bit embellished. There were details that weren't even accurate as far as the original crime scene. So that felt really hurtful to a lot of us. And I do want to say that when I spoke with my cousins, it was very afterwards. They, didn't have a chance to see that live, but their biggest concern was that they had heard about it and how were we doing, because they knew that that would have been gut wrenching for us, and it was. So that's my reaction.
And to piggyback on what Anna Maria said, Eric had just said, we need you strong. And they both really, they mirrored our frustration, but they also said, let it go. We need to focus on moving forward. And so that is our focus.
Thank you. Hannah, you now have the floor. Hannah, if you still have a question, I think you should be unmuted.
Sorry, actually, it's Natalie Morales. I just wanted to follow up on that. You talked about the emotions that Eric and Lyle sort of conveyed in that moment. I'm wondering if you can give us a little more detail as to how they're doing now. Of course, following Friday's news conference from Hackman to then the turn of events yesterday with the governor announcing this risk assessment.
Cautious optimism, I think is really the way to say it. Also, it's been a real learning process for us as a family and for them too, because this is a new process that that the governor is using in California. So when we talk about parole boards and going to parole, they have lots of experience with other inmates, seeing them go through that process, understanding what that's about, what it looks like, getting turned down, that type of thing. So they have a really good, clear grasp on that. And so this is a little bit of a newer process, this risk assessment being done through the parole board initiated by the governor. Oh, excuse me. So I think that they are cautiously optimistic, but we're all sort of still trying to figure that out.
And then just adding to that, one of the things that they are also very aware of is that, and they try to just follow in the lines of caution, they are the first life without parole prisoners on this path. So when we look at any advancements or developments, it's definitely with hope, but also understanding that there are no promises.
Thank you. And I'm going to call on Emily. If you still have a question, you have the floor.
Hi, Emily Valdez here. So there are two remaining options. Well, actually three still, but two more likely remaining options. One would be the resentencing. The other would be the clemency from the governor. How confident, which path do you think is most likely, and how confident are you that they actually will be released under one of these?
I don't feel qualified to answer that question. I feel like that's a legal team question for me. I don't know what's more likely. I just hope something. That's it.
Agreed. I feel the same. It's I wouldn't even know where to start with that other than we're just hopeful. And to know that we're now having a clear, direct response from Newsom is just, I think, beyond our expectation at this point. So knowing that there is a timeline that has been started by his initiation of this investigation, we're just holding on to that hope and moving forward as we can.
And do you know if the governor's investigation will be done by the time their next court hearing on March 20th?
That I don't know. I know that they have 90 days, but we have not been given any more information than just knowing that it's been initiated.
Okay, and just for clarification, can you each clarify your relation to Lyle and Eric for me?
Sure, I'm a first cousin. So Jose was my mother's brother.
And I am a second cousin. My mother is Karen Vandermolen, which has been interviewed multiple times, but then my grandmother is Joan. So
Jamie, you're up next. You have the floor.
Hi. Previously, you guys had expressed concerns about conflicts of interest within the DA's office. And earlier you mentioned Nancy and Brock, who, filed, were going to file that lawsuit against DA's office for discrimination, as well as Milton's lawyer, I think, being hired into the office. Are those still concerns for you guys? Are you doing anything about it? Still calling on someone else to take over the investigation, or what's the status on that?
Those were certainly concerns of ours, but we're not taking any sort of formal steps regarding that. That's one of the reasons we are just so thrilled that Governor Newsom decided to step in and initiate this process himself. We're super, super grateful.
Thank you.
And we're going to do one last question. Edgar, you're going to have the floor.
Hello, you hear me?
Yes.
Yeah, I'm Edgar Munoz. Have you thought of the possibility that if the verdict is not in your favor and Eric and Lai continue in prison? And Ana Maria, do you speak Spanish? My news is in Spanish.
Muy bien. Yeah. Lo comprendo perfectamente bien, pero no lo hablo muy bien.
Okay, in English is good.
So the possibility that it doesn't go our way, that's a possibility. We would be foolish if we did not recognize that, understand that, and emotionally prepare for that. That's a real possibility. I hope not. Based on what we communicated today, I think it's quite clear that Lyle and Eric really do meet the standard for this process. So I'm grateful that it's going to be a non-political process. I'm grateful that it's going to be a transparent process, that everybody will have a chance to see the results. But you're right. You're right. There are no guarantees. That was also communicated very clearly from the governor's office. So we'll just have to see the investigation, how it goes, and the results.
Thank you.
And that brings our time to an end. Thank you, everyone, so much for joining. If you have any follow-up questions, please feel free to email me. And I'll get back to you. Bye, everyone.
And that concludes that press conference. There's no guarantee that the Menendez brothers will get either the clemency from Governor Gavin Newsom, or even yet get that new trial that may that could still set them free. And on top of it, even if they do get clemency, there's no guarantee as of yet that neither Lyle or Eric will pose any risk once they are freed. When we get more information on this case, I'm bringing it right here to you. Whether it be an interview, a hearing, whatever that case may be, I'll bring it right here to you. Bethea'S Byte Reloaded. Next up, a North Carolina man who created the viral "Thank You Jesus" yard sign is accused of a child sex crime. 25-year-old Lucas Timothy Hunt is charged with one count of second-degree sexual exploitation of a minor. Yeah, this is the guy right here, Lucas Timothy Hunt. Hunt is from Asheboro, North Carolina. He was taken into custody with one count of second-degree sexual exploitation of a minor on February 25th, according to the Randolph County Sheriff's Office. According to outlets WSCO-TV, WFMY, and Fox 8, police allege Hunt received a sexually explicit video of a minor. Further details were not immediately known. The investigation began in January 2025 when members of the Invictus Task Force responded to a tip from the National Center for Missing and Exploited Children. That's according to that statement. Hunt was subsequently identified as a suspect. The task force, which works with the Homeland Security and the State Bureau of Investigation, fights against internet crimes against children, ICAC, sexual abuse, trafficking, and the exploitation of children using a collaboration of resources as a force multiplier, the statement says. According to outlets, Hunt was a founder of the Thank You Jesus Mission, a nonprofit organization that raises money for local Christian groups. Its website says Hunt became popular in 2016 after he put up Thank You Jesus yard signs around his hometown in Asheboro. The organization's president, Constance Connie Frazier, told Fox 8 the board is expected to meet soon to discuss Hunt's future with the mission. Thank You Jesus has always been about more than one person. It's about people who love Jesus and want to show their appreciation, Frazier told the outlet. Although we cannot comment on the criminal charges against Lucas Hunt, we can share that he blessed thousands of people through the Thank You Jesus signs. People have contacted the organization for comment, but did not hear back in time for publication. Hunt is being held in Randolph County Detention Center on a $75,000 secure bond and had his first court appearance on February 26, according to the sheriff's office. It is unclear if he has entered a plea or retained an attorney to speak on his behalf. Now, even I gotta admit, that's crazy enough. A guy that's doing so much good, and now he's turned over and doing this something this disgusting, this inhumane. I wanna say I hope it's not true. I hope he does clear his name, but if he doesn't, then let justice be done. Well. All right. Before I get to this next story, I gotta hit you all with a disclaimer. This is what I'm about to report right now is not going back to the old Bethea'S Byte. What I'm about to bring to you right now is not gonna hold any bearing with what I believe politically or what I believe to know personally about Donald Trump. Okay? Now that I got that straightened out, let's get to this next story. As you can see on the headline, Donald Trump named in Jeffrey Epstein flight logs released by his own Attorney General. According to the logs, Trump flew with his then-wife Marla Maples and daughter Tiffany with Epstein twice. President Donald Trump's name appears in Jeffrey Epstein's flight logs, released by his own Attorney General on Thursday, February 27th. People magazine reviewed the flight logs and found Trump's name a total of 7 times. He was mentioned on page 24 of the first flight log dated October 11th, 1993, Mentioned twice on page 27, along with then wife Marla Maples and their daughter Tiffany and a nanny on May 15th, 1994. All three of those dates had the initials JE for Jeff Epstein listed on the same flights as Trump. GM, possibly Galani Maxwell, was listed as a passenger on the October 1993 flight. The release of the files related to the financier accused of sex trafficking came a day after Attorney General Pam Bondi said on Fox News that the Justice Department was set to release flight logs and names of people associated with Epstein. What you're going to see is a lot of flight logs, a lot of names, a lot of information, Bondi told Jesse Waters. But it's pretty sick what that man did along with his co-defendant. I'm just going to let this picture linger here for a little bit and let the picture speak. Okay, sure. Bonnie said Epstein had more than 250 alleged victims. The first phase of files released today sheds light on Epstein's extensive network and begins to provide the public with long overdue accountability, Bondi said in a statement in part on last Thursday. The first materials released included flight logs, an evidence list, redacted pages from a contact book, and redacted pages of a masseuse list. Much of the files have been previously disclosed through court cases or otherwise. The appearance of a person's name on the flight logs is not an indication of wrongdoing. Most of the individuals were presumably on Epstein's plane for legitimate reasons, for legitimate business, political, or social reasons. Okay, I'll let that linger long enough. Let me continue. In a letter to FBI Director Kash Patel, Bondi claims she only received about 200 pages of documents, which consisted primarily of flight logs. Epstein's list of contracts and a list of victims' names and phone numbers before Patel took office. On last Wednesday, she learned from a source that the FBI field office in New York had thousands of pages of documents related to the investigation and indictment of Epstein. Bondi requested the FBI deliver the rest of the documents by 8 a.m. Friday, February 28th, and asked Patel to investigate why the request for all documents was not followed. In 2019, Epstein, facing sex trafficking charges, died by suicide in a New York City jail. He had ties to high-profile figures like Prince Andrew, Bill Clinton, and Trump prior to his arrest. Neither Clinton nor Trump have been accused of any wrongdoing. Trump has said that he once considered Epstein a terrific guy, but that they later had a falling out. Epstein was accused of trafficking girls as young as 14, according to a federal indictment. He faced a 45-year prison sentence. Epstein previously pleaded guilty to soliciting a person under 18 for prostitution in 2008 and served just over a year in prison. Maxwell, Epstein's co-conspirator, was convicted of sex trafficking in 2022 and sentenced to 20 years in prison. And as I'm looking at the comments and a couple of comments here, Elizabeth made this comment saying that it was just a matter of time before folks tried to slate a Trump family flight with a subsequently accused predator as being newsworthy. We've all come to expect nothing better from a liberal news. This person just basically just slamming this whole thing, slamming the whole thing because it's People Magazine reporting it, and not anything like it's Newsmax or OAN or something like that. Callie went ahead and made more of a unbiased statement saying that it's not about the flights, it's about the island and who went to the island. A massive amount of people used his planes. They didn't go to the island. All we need is the island list. We already knew Trump took a flight. So did Hawking. Are we going to cry rape about Hawking because he took a flight? Well, we just have to wait and see once that list comes out, if such a list comes out. But it's all there. He's been named on the flight logs, but it also says that he hasn't been accused of any wrongdoing. Next up, a Florida driver was allegedly so drunk he was completely unaware why police stopped him after he slammed into a woman's parked car. 19-year-old Gabriela Alejandra Rios Flores was ejected from the parked car and later died of her injuries. On your left is the banged up, busted up car that the 19-year-old was driving, or maybe this was the driver of this car here. I'll tell you in a moment. On the right, you should see this is Nicholas Devon Robinson. He was according to this, he was allegedly so drunk and he was completely unaware as to why police stopped him after slamming into a parked car. The woman inside the parked car was ejected and later died of her injuries. The crash occurred on the MacArthur Causeway, temporarily closing the areas between Fountain Street and 5th Street and Alton Road on Friday, February 21st, according to the Miami Beach Police Department in an X update. 24-year-old Nicholas Devon Robinson, who was on his way back from a birthday party at a South Beach bar, was behind the wheel of a silver Polestar Model 2, as reported by WSVN. According to CBS affiliate WFOR-TV, NBC affiliate WTVJ, and ABC affiliate WPLG, citing the arrest report moments before driven by a 19-year-old Gabriela Alejandra Rios Flores. Let's go to Local 10 News. This is from ABC affiliate WPLG.
An update as well right now after a crash on the MacArthur Causeway. We have now learned one of the victims has died.
Meanwhile, the man accused of causing the crash appeared in court today. Local 10's Annalise Garcia is live in Miami Beach with what happened during his hearing. Annalise.
And Christy, Syra, before we get to those details of the hearing, a few things on the crash itself. A police officer actually witnessed what was going on out here. He helped the victim move her green Jeep Wrangler to the shoulder on the westbound lanes of the MacArthur Causeway behind me. Let's take you to video if we're not already there so you can see for yourself how intense this crash was. It closed down the lanes of the MacArthur Causeway, both east and westbound, for hours. Police say the subject in this case, Nicholas Devon Robinson, was driving at 100 miles per hour on the westbound lanes of the MacArthur Causeway when he hit a median and then slammed into that parked Wrangler. We can take you again to this very shocking video where you can see these mangled cars, the Wrangler and his silver SUV, a Polestar Model 2. The Wrangler even more mangled than the other car. When Robinson slammed into the Wrangler, police say the Jeep went over to the eastbound lanes where it rolled and finally came to a final stop. The victim ejected from her car and then taken to the hospital where, as you know, she later did die. Today, Robinson's charges were upgraded to vehicular homicide. Take a listen to how that went.
We're here because he's driving at a high rate of speed, I guess shortly after midnight on February 21st, and smashes into a car going west on MacArthur Causeway. They say he's driving, they believe, 100 miles an hour in a 40-mile-an-hour zone. He has slurred speech, odor of alcoholic beverage. In fact, he didn't even know he hit another car. He said, "Did you get the other car?" And he struck the vehicle. The victim was ejected. And he said he's out celebrating his birthday. So I guess it was his birthday and the victim's death day because she died. That being said,
So the victim in this case was 19 years old. Her name was Gabriela Alejandra Rios Flores. She was the driver of that green Jeep Wrangler. Still so many questions surrounding this case. We're working on getting you answers. As soon as we do, we'll let you know on air and online. We're live in Miami Beach. Annalise Garcia, Local 10 News.
Honesty. If I were, I would hate to be on the road that night. Because one, I would know better than to get behind the wheel drunk and risk not only my life but everybody else's that's traveling up and down those roads. It's enough you're risking your life traveling up and down those roads sober. But drunk, where the fact that the opportunity where you can kill somebody has just gone up in degrees. Couldn't do it. This is why that's the reason why it never works out well for anybody, the driver or the victim. It never works out. Okay, I got a few more stories left before I wrap this up, and this is everything that went down on this past Friday. First up, Ellen Gillen, sentenced in the death of her terminally ill husband. She pleaded no contest to shooting Jerry Gillen in January 2023, then barricading herself in his hospital room. And I believe we may go into the courtroom right now for that sentencing.
And I did during that last break that we took to preview the additional materials that the defense submitted with the additional letters that were attached.
Thank you, Tricia. Copy here for the defense, and I'll approach with. This copy.
But I just will ask you and your attorneys to please stand while I'm imposing sentence. Typically, I would have you come forward, but I want you to be able to rely on the walk or the table if you need to, ma'am. So, and I just want to take this opportunity to remind everyone as well that no outbursts or emotional expressions will be tolerated. You'll be removed from the courtroom if that does happen. So to kind of reiterate, Ms. Gillen, you're here on the counts that your attorney stated. You've got the 1 count of assisting self-murder or manslaughter, 2 counts of aggravated assault with a firearm, and those refer to Mr. Jackson, the security officer, and Mr. Conte, both of whom testified here today. And then you have that 4th count of aggravated assault on a law enforcement officer with a firearm. And there were 6 officers who were named as victims in count 4 of the indictment. So the score on the criminal punishment score sheet is 115 months, which would be 9 years and roughly 8 months. The state, as you know, has agreed to waive the minimum guidelines and agreed to cap your punishment at 10 years prison. And I first want to talk about some of the testimony that I've heard today. And Ms. Gillen, I accept your testimony today that you've given with respect to the fact that Jerry was suicidal. I know there's no records that document that, but I accept what you stated, that he told you and continued to express that he was suicidal. I think that makes sense that a husband would confide in his wife of 53 years with respect to his serious emotional condition. I accept your testimony, ma'am, that his condition was worsening. Can you hear me okay? Yes. Okay. I accept your testimony that you and Jerry jointly decided to commit suicide, that you believe that was the only way out. And I accept your testimony that you do not remember staff informing you about comfort care or hospice. I think the doctor testified honestly with respect to what hospital procedure is, but I think it's highly likely that that either didn't happen or that you don't remember it. Also, I accept Dr. Danziger's testimony that you continue to not be a risk of danger to the community and that you were suffering from some sort of mental health episode on the date of the incident. I want to point out that, as everybody knows, this is not just a case about you and your terminally ill or very ill husband, because we've heard from the fact, from the testimony today, that there are many other victims in this case. And by entering your plea, you've admitted to having pointed a firearm at 2 hospital employees. You've admitted to having pointed a firearm at many Daytona Beach police officers as well. And we've heard today that there were 34 patients, 33 other patients on that floor who potentially had their treatment, their medical treatment disrupted, not to mention putting them in fear for their lives and perhaps their family as well. And then I don't even know how many hospital employees and their family members were impacted by the decision that you made. And it has come out today that you're educated, you have a master's degree. Some of these letters described you as smart and patient and kind and generous and thoughtful, but your actions on that date were none of those things. And your attorneys identified in the sentencing memo a few other similar cases where an elderly defendant had killed his or her spouse in some type of a mercy killing where that spouse was seriously ill. And the difference between those 3 cases that were identified and this one is the other victims. And that's what makes this case different to me. A lot of the letters that were sent in and even some of the testimony today talked about aid in dying laws and how Florida should have such a law. This is not the proper venue to make that argument. I am not a lawmaker. That is not my focus. That's an argument that needs to go to the Florida legislature and them only. Now, that's not to say that I'm unsympathetic to you, ma'am, because I can't fathom the difficulty of watching your husband's medical condition deteriorate to the point that he was in that constant kind of pain and wishing that he were dead. I can't understand that. I can't begin to understand how difficult it would have been for you to actually pull the trigger to assist your husband in ending his own life. I do believe that is what you did, and so the punishment that I'm going to impose in this case is related to the other charges against you primarily. I've heard from the victims today, and I am highly persuaded by that testimony about the trauma that was inflicted on them. So, ma'am, I am going to adjudicate you guilty. You will be a convicted felon as a result of this incident. I'm going to sentence you to 366 days DOC, that's prison, and you will get credit for the 42 days that you've served. That'll be followed by 12 years of probation. The probationary terms are that you have to write letters of apology to the civilian victims and the 6 law enforcement victims that were identified in the indictment. And then this is an important part of the sentence as well. I want you to perform a minimal amount of community service hours per month for as long as you're physically able to do that. I want you to do 8 community service hours a month, so that's maybe 2 a week. And I don't care what you do, but I want you to realize, ma'am, that your life still continues to have value and you can contribute to society. You can even do work from home, like telephone or even via an internet connection. Again, I don't care what you do, but I want you to give back and I want you to enjoy the feeling of giving back to others as well. And then last but not least, there's going to be a mental health evaluation as a condition of probation, and you'll have to comply with whatever, if any, follow-up is recommended. It could just be take medication, but whatever the professional recommends is what you'll have to do. There are court costs of $770 plus $100 cost of prosecution and $100 cost of investigation to the police department, and you'll have to pay those off as a condition of your probation. So they're going to take you into custody today to begin serving that sentence, and again, you'll get credit for those 42 days that you've already served. Is there anything else that I need to address today?
Nothing from the state, Your Honor. Thank you so much, Your Honor. I appreciate it.
Okay. Thank you, folks.
Thank you.
And there you have it, folks. Ellen Gillen has been sentenced to 366 days in prison after pleading no contest to shooting her terminally ill husband as he lay in a hospital bed. In exchange for that, prosecutors waived sentencing guidelines, including a 3-year minimum for one charge and agreed to a 10-year cap on her prison sentence. Judge Catherine Weston said that she was sentencing Ellen not for pulling the trigger to help her husband die, but for the effects her behavior had on other patients in the hospital at that time. Ellen Gillen sentenced to 366 days in prison for shooting her terminally ill husband. Next, at a 3-day hearing, the mother of Andrew, Alexander, and Tanner Skelton is asking a probate court to declare her sons legally dead. The mother of 3 brothers who went missing the day after Thanksgiving in 2010 is now asking the state to declare them legally dead. Tanya Zuvers filed in Lenawee County Probate Court back in December 2023 requesting that her sons, Andrew, Alexander, and Tanner Skelton, officially be declared dead. A 3-day probate court hearing is scheduled tomorrow. Andrew, Alexander, and Tanner were 9, 7, and 5 years old respectively when they were last known to be alive. The Skelton brothers spent Thanksgiving that year with their father, John Skelton, at his home in Morenci. When Tanya Zuvers, their mother, didn't hear from John about a pickup time the next day, she went to his home. No one was there. Zuyers tracked John down to a nearby hospital where he was being treated for a broken ankle. According to the National Center for Missing and Exploited Children, he told hospital workers that he injured his ankle while trying to commit suicide. John told police that he gave the boys to an organization to protect them from Zuvers, accusing her of abuse. Still, investigators have never been able to verify that the group exists. Police say John provided other conflicting accounts of who he gave the boys to. John is now serving a 10-year sentence for unlawful imprisonment charges connected to his son's disappearance and is scheduled to complete his sentence in November 2025. After years of searching for clues, including a possible connection to bodies found in Montana, Zuvers says it's time for closure. In a previous statement regarding her decision to have the boys declared legally dead, she said it did not come lightly and was definitely a difficult decision to make. No parent wants to lose a child, but to have the courts step in and declare them deceased is just unfathomable. At the end of the day, one person is responsible for the disappearance of my sons, she wrote. That person, at one point, claimed the boys will hibernate until they graduate. As of today, June 14th of 2024, all 3 boys are over 18 and all would have graduated high school, yet they have not been returned to me and are still missing. It's a sad story when a child has been missing for so long that the worried parent has no other option, no other choice but to declare that child deceased. It's even, in this case, it's got to be heartbreaking when it's 3. I hope that before this happens, I hope by some miracle that those boys are found. And you guys in the Michigan area can help. call your local authorities immediately. Call 911. If you want to submit your tips online or by phone, you can do it through the FBI. That number is 1-800-CALL-FBI, 1-800-225-5324, or you can submit that tip anonymously at tips.fbi.gov. You can call in your information to the National Center for Missing and Exploited Children. That number, 1-800-THE-LOST, 1-800 843-5678. But whatever you do, please, I say this often enough, if you see something, please say something. That way we can do something. Let's find those brothers and let's bring them home safe, right? Next up, we have a trial I believe is already started in Iowa. It's being called the Visions of Violence murder trial. Iowa versus Christopher Behal. While in a hospital after a crash, Christopher Behal requested a welfare check on his girlfriend because he had visions of violence. An Iowa man accused of murdering his girlfriend, then crashing his vehicle under the influence, is facing life in prison if convicted at trial. Christopher Behal allegedly murdered Taylor Escontrias in March of 2024. Court documents accuse Behal of using multiple dangerous weapons to fatally assault Escontrias. He was then taken to a hospital after crashing his vehicle into a light pole. During a previous court hearing, a detective testified that while at the hospital, Behal requested a welfare check on his girlfriend because he had visions of violence. That's according to a report from KLJB. Authorities reportedly found Escontrias deceased at the couple's home, along with a bat and screwdriver covered in blood. Behal has pleaded not guilty. Behal is facing 7 charges, including first-degree murder, and his trial is scheduled to begin tomorrow with jury selection. And if there's any information on this as the case goes down, I'll be sure to bring it to you right here. Next, the Georgia Court of Appeals have ruled the statute of limitations expired for charging the men in Tara Grinstead's body burning case from 2 decades ago. An appeals court has thrown out pending criminal charges against 2 men previously convicted of concealing the death of Georgia teacher Tara Grinstead, whose 2005 disappearance baffled her family and investigators for more than a decade. The Georgia Court of Appeals ruled Thursday that the statute of limitations had expired when prosecutors in rural Ben Hill County charged the men with crimes stemming from the burning of Grinstead's body in a rural pecan orchard 2 decades ago. Prior convictions in the case weren't affected. Bo Dukes, along with his high school friend Ryan Duke, are both serving prison sentences related to concealing the death of Grinstead, a former beauty queen who went missing in 2005 from her small town of Ocilla. The investigation of the 30-year-old's disappearance spanned more than a decade, consuming the small town in rumors and speculation before police arrested friends and former Irwin High School students Ryan Duke and Bo Dukes in early 2017. New charges were lodged against Bo Dukes following Ryan Duke's high-profile 2023 murder trial, where Duke was acquitted of murder charges after testifying against his former roommate, saying Bo Dukes killed Grinstead before roping him into burning her body on the Dukes family pecan orchard. Recently, Dukes challenged some of those charges against him in Ben Hill County, arguing that they were filed too late and constituted double jeopardy, meaning he shouldn't be tried twice for the same thing. In recent rulings, the appellate judges sided with Dukes on the time bar issue. They determined while law enforcement had enough information to warrant an arrest as early as November 2005, the indictment against him filed in June 2017 was issued beyond the applicable 4-year statute of limitations. We conclude that law enforcement had probable cause to arrest the two men by late November 2005, the court's ruling said. Police contended they lacked sufficient evidence to make arrests in late 2005 when they searched the pecan orchard based on the man's tip but found no sign of Grinstead. Nevertheless, the appeals court ruled that the 4-year time limit expired long before either man was charged in Ben Hill County. However, the court did not support Duke's double jeopardy claims. The judges noted that the charges he faced in Ben Hill County arose from a different course of conduct, separate from previous convictions related to his actions in Wilcox County. During a post-verdict press conference following Ryan Duke's trial, prosecutors said they did not foresee future murder charges against Bo Dukes in Irwin County because they believe Ryan Duke is the person responsible for Grinstead's murder. Dukes was also indicted in 2019 in 2 rape cases with no connection to Grinstead's death and disappearance. A judge sentenced him to 10 years in prison for each reduced rape count, plus 5 years for illegally possessing a gun. According to court records, the plea deal allows the time Duke serves for Grinstead's death to also count toward those sentences. Ryan was denied parole in June 2023 and will not be released from custody until his maximum release date, which is February 12, 2027. I really have nothing else to say to that. The end of the article said it all for me. Now, a story that's been buzzing for the last few days is the death of Hollywood megastar and 5-time Oscar winner Gene Hackman. According to the sheriff in Santa Fe, he and his wife may have been dead for days or weeks. Authorities are investigating after the Oscar-winning actor and his wife were found dead in their Santa Fe home. Legendary actor Gene Hackman and his wife tested negative for carbon monoxide, but what caused their death remains unknown. The sheriff leading the investigation said this on Friday. Hackman was likely dead for more than a week before his body was found because his pacemaker last showed activity on February 17th, 9 days before maintenance and security workers showed up at his home, said Santa Fe County Sheriff Aiden Mendoza. The 95-year-old Oscar winner was found on Wednesday in an entryway of the couple's Santa Fe home. His wife, 65-year-old Betty Arakawa, was found lying on her side in the bathroom. A dead German Shepherd was found in a kennel near Arakawa, Mendoza said. There were no obvious signs of foul play, and initial autopsy findings found no external trauma to either individual, Mendoza said. The sheriff said he spoke with the pathologist from the New Mexico office of the medical investigator, who said that both Hackman and Arakawa tested negative for carbon monoxide. No cause or manner of death has been determined, and it will be up to the medical investigators to answer many of the questions about when and how the couple died. Dr. Philip King, the retired chief medical examiner in Maricopa County, Arizona, said it would be unlikely for a person who tests negative for carbon monoxide initially to be found to have been poisoned by it. He also said the moment when a pacemaker stops working could mark point when a person dies, but not always. If your heart required a pacemaker, there would certainly be an interruption at that point, and it might be the hallmark of when the death occurred. But it's not necessarily because some people get a pacemaker to augment things, not necessarily replace things, King said. Investigators are trying to figure out when the last time anyone saw or spoke to the couple, who were known to guard their privacy. There is no surveillance as we know of right now in the interior of the residence or the exterior of the residence that is going to help us determine a timeline or events that happened. Authorities released a few other details at a Friday news conference about the deaths. According to a search warrant affidavit, an open prescription bottle and pills were on a countertop near Arakawa. Authorities who later searched the home retrieved medication that treats high blood pressure and chest pain, thyroid medication, Tylenol, 2 cell phones, a monthly planner, and records from medical diagnostics testing. Detectives wrote in a search warrant affidavit that investigators thought the deaths were suspicious enough in nature to require a thorough search and investigation. No gas leaks were discovered in and around the home. A space heater was next to Arakawa and may have fallen when she abruptly fell to the floor, according to the affidavit. A maintenance worker who showed up to do routine work at the house could not get inside the house and called a security worker, spotted 2 people on the ground, Mendoza said. The worker who called 911 told an operator he did not know if they were breathing. I have no idea, the subdivision's caretaker said on the call. I am not inside the house. It's closed. It's locked. I can't go in. But I can see she's laying down on the floor from the window. He and another worker later told authorities that they rarely saw the homeowners and that their last contact with them had been about 2 weeks ago. Gene Hackman was one of the most accomplished actors of his generation, appearing as villains, heroes, and anti-heroes in dozens of dramas, comedies, and action films from the 1960s until his retirement in the early 2000s. He was a 5-time Oscar nominee who won Best Actor in a leading role for The French Connection in 1972, and Best Actor in a supporting role for Unforgiven 2 decades later. He also won praise for his role as a coach, finding redemption in the sentimental favorite, Hoosiers. He met Arakawa, a classically trained pianist, at a California gym in the mid-1980s. They moved to Santa Fe by the end of the decade. Their Pueblo Revival home sits on a hill in a gated community with views of the foothills of the Rocky Mountains. In his first couple of decades in New Mexico, Hackman was often seen around the state capitol and served on the board of trustees for the Georgia O'Keeffe Museum from 1997 to 2004. In recent years, he was far less visible. Aside from appearances at award shows, he was rarely seen in the Hollywood social circuit and retired from acting about 20 years ago. Hackman had 3 children from a previous marriage. He and Arakawa had no children, but were known for having German shepherds. As far as the case goes, I hope that they finally come up with an answer as to what happened to Gene Hackman and his wife. As far as my memory of him as an actor, I can give you the movie and I can give you the role because that was what hooked me onto him. The movie was Superman, the movie. And if you'd heard the title, then you already know the role. Lex Luthor, the thorn in Superman's side. He played Lex Luthor as well as anybody could play that role at that time. And yes, I did see him in Hoosiers. I did see him in Unforgiven, and I even threw it back to the French Connection, and I did see that, and he was that good of an actor. He was that good. So, as far as the investigation goes, I hope and pray that there truly was no foul play. It was just their time to leave this earth. And Gene, you've done a great job acting. Now it's time for you, your wife, and your German Shepherd to rest in peace. God bless you all, and thank you for the contributions. Next up. Oh, good. I do have the trigger warning on for this one. Okay. Next up. According to police, a teacher who also worked as a beauty advisor is accused of unlawful sexual conduct with a teen boy. This is our teacher, ladies and gentlemen, Dulce Flores. She's a California high school teacher who claimed on her LinkedIn profile to also work as a beauty advisor, and she's been accused of engaging in unlawful sexual conduct with a former student who was underage at the time. She was a teacher in Riverbank, California, arrested on Tuesday, February 20. Wait. Friday's the 28th. February 25th by Stanislaus County Sheriff's Office, according to the Riverbank Police Department. Flores, who has been a Spanish language teacher with Riverbank High School since 2016, was arrested following accusations that she engaged in an inappropriate relationship with a 17-year-old male student in 2023. According to Flores' LinkedIn profile, she also worked as a beauty advisor for a cosmetics company. It wasn't immediately clear when the investigation began. Riverbank police say they began looking into the matter after a school official was tipped off by an unrelated party about the alleged relationship. Flores, who graduated with a bachelor's degree in Spanish language and literature in 2014, was arrested in her home. Okay, let me get this scene right now. This glamour shot has her looking a lot like actress Penelope Cruz, but that's just my opinion. You have your own, and I would love to hear it. Anyway, she was taken to Stanislaus County Jail in lieu of $20,000 bail, though court or jail records did not show her information as of Friday at noon. People has reached out to the Riverbank Unified School District and the cosmetics company for comment. The district previously told the Modesto Bee that they will cooperate with investigators if necessary and have placed Flores on leave as the investigation continues. Flores has been charged with one count of unlawful sexual intercourse with a minor, per Riverbank police. It wasn't immediately clear if Flores has entered a plea or retained an attorney to speak on her behalf. An investigation is ongoing, and police are urging anyone with information to contact them. Their number is 209-869-7162. 209-869-7162. Anonymous tipsters can also contact police at 866-60-CRIME, 866-602-7463. And now we end this particular article with two public service announcements. First, if you or someone you know has been a victim of sexual abuse, you don't have to be a statistic in this. There is someone available that can help you. You can text the word strength, STRENGTH, to the crisis text line at 741-741 to be connected to a certified crisis counselor. Again, the word is strength, and the text number is 741-741. Also, if you suspect child abuse, no child deserves to be abused. No child deserves to be a victim of abuse. If you suspect child abuse, you're asked to call the Child Help National Child Abuse Hotline. That number is 1-800-4-A-CHILD, 1-800-422-4453, or go to childhelp.org. All calls are toll-free and confidential, and the hotline is available 24 hours a day, 7 days a week, in more than 170 languages. Help is just a phone call away from keeping a child from becoming a statistic. That number again is 1-800-4-H-CHILD, 1-800-422-4453. Next up, there's a teacher charged in the deaths of North Carolina high school football players killed in an ATV accident. The arrest comes months after the August 2024 deaths of Lane Jones and Jaden Reynaldo. A teacher's been charged in connection with the deaths of two North Carolina high school players killed in an ATV crash last summer. Ashley Marie Darity, age 34, is charged with 2 counts of felony involuntary manslaughter related to the August 2024 deaths of Lane Jones and Jaden Reynaldo. That's according to the Alcohol Law Enforcement Division of the State Department of Public Safety, confirming in a statement shared with People magazine. Darity, who was arrested on February 13th, was released on a $20,000 secure bond per court records reviewed by People magazine. Jones and Reynaldo were riding a 2015 Polaris Sportsman ATV on August 25, 2024, when they went around a curve and crashed a four-wheeler into a tree in Transylvania County. That's according to state authorities per the Transylvania Times, USA Today, and NBC News. Both were pronounced dead at the scene. The State Department of Public Safety said in a statement that alcohol is believed to be a factor in the crash that killed the boys, who were football players at Rosman High School, according to the Transylvania Times. Authorities believe the teenagers attended a house party prior to the crash. A school district official confirmed to NBC News and USA Today that Doherty was a substitute teacher in the Transylvania County Schools District from 2021 to 2023. It's unclear which school she worked for, though Rosman High School is part of that district. 2 others have also been arrested amid the investigation. Brandon Kane Rathbone and Patricia Faye Whitehead, both of Balsam Grove, North Carolina, were each charged with aiding and abetting a person less than 21 years of age in the possession and or consumption of alcoholic beverages, per the statement shared with People magazine. The State Department of Public Safety said the charges stem from a previous incident discovered during this investigation that occurred at the same residence. Authorities said the investigation into the fatal crash remains ongoing. The Transylvania County School District mourned the loss of the 2 students in a statement shared on social media in August 2024. In moments like these, words often fall short, the district said. Our hearts are broken, and we are grieving together as a community. The loss of such young, vibrant lives is a stark reminder of how precious life is and how deeply we are all connected. People has reached out to Doherty's attorney, Sean Devereaux, for comment. It's a real shame. Couple of young student athletes who really had their lives snuffed out, all because of somebody else and alcohol. I hope those boys get the justice they're seeking, that they deserve. Finally, a woman was charged after her boyfriend was found locked in a storage for days. The question is, why does he say that the charges are bogus? 52-year-old Robin Deaton was arrested in North Carolina on February 26th and accused of locking her boyfriend in a unit for days without food or water. She's facing attempted murder and kidnapping charges, according to Monroe Police Lieutenant and Public Information Officer Morgan Malone. In a 911 call obtained by People magazine, which was released by Union County Emergency Services, her boyfriend claimed she'd locked him in the Cooper storage facility in Monroe. Malone told People magazine that he'd been in the facility since Thursday, February 20th, without any food or water. However, the man has since claimed that he fell asleep in the unit. His girlfriend didn't realize and locked the door. Malone, he mentioned this in an email. The male, identified as Gary Oxendine, told ABC-affiliated local station WSOC that the charges are reportedly bogus and a mistake. It's just a bunch of bogus charges. I mean, she shouldn't be up there charged with attempted murder, attempted kidnapping, Oxendine told the station's Channel 9. He claimed that Deaton had left to get them something to eat before he fell asleep in the unit. He alleged she didn't see him and he didn't hear her when she shouted for him. She then left and locked the door thinking he'd gone, per the outlet. Oxendine said, "She thought I had gone with an ex-girlfriend. That's what it all boils down to, and I hadn't." She said she came the next day, but I sleep hard and I fell asleep. I had been working for a couple of days. Malone said in an email to People regarding Oxendine's comments. The detectives followed the facts of the case and with corroborating evidence to support the charges. The charges have been filed and the case has been turned over to the district attorney's office. Unfortunately, it is not uncommon for a domestic violence victim to recant their initial testimony. Oxendine's comments came after he said in the 911 call obtained by People magazine, "I've been locked in a storage unit for about a week now, and I've just now found my phone. My girlfriend locked me in here. She double locked my lock, and I don't know how she put me in here, but she put me in here," he alleged. Oxendine claimed he was in Unit 43, saying when questioned whether he needed emergency services, "I just need to get out of here. I just can't breathe. I haven't had nothing to drink or anything," he said. Oh, and this is the storage facility. An incident report previously obtained by People magazine confirmed that police officers responded to 1950 Old Charlotte Highway in reference to suspicious circumstances on Monday, February 24th at approximately 2:13 p.m. The report listed the crime as false imprisonment. Malone told People magazine on February 27th that the man said Dean had allegedly convinced him to crawl to the back of the storage unit to grab something for her before she slammed it shut and said, "This is what you get." The officer said of the case, according to CBS affiliated local station WBTV, "This is bizarre. In 15 years, I have not seen anybody who has been locked in a storage unit. The storage unit was described to me as being a hoarder's paradise," Malone added. "As soon as the officers opened up the door, things started falling out. The further they opened it, the more stuff fell out." Police added that the man had been in complete darkness, hence why he struggled to find his phone, according to the outlet. The Cooper Storage Facility and Union County District Attorney's Office did not immediately respond when contacted by People for comment. And one last public service announcement before I get out of here. If you or someone you know are experiencing domestic violence, I say as always, you do not have to become a statistic. You are urged to call the National Domestic Violence Hotline. That number is 1-800-799-7233. It's 1-800-799-SAFE. Or go to the www.thehotline.org. All calls are toll-free and confidential. The hotline is available 24 hours a day, 7 days a week, in more than 170 languages. You do not have to become a statistic. The hotline, your help is just a call away at 1-800-799-SAFE. 1-800-799-7233. And as far as my opinion on this goes, I just got a weird feeling that this is gonna be North Carolina's version of a case we just got finished with. The case of Sarah Boone. And we all know how crazy that got, right? I am just saying. Alright, ladies and gentlemen, that's all I've got for this week. I want to thank you all so much. You have been absolutely amazing. So let me go ahead and get this out of here. Get up out of here. And if you want to get in contact with me, I'm on Facebook at Bethea'S Byte Reloaded. On X at EKB316 in all caps. On YouTube at Bethea'S Byte Reloaded. On Instagram at EKB316 in lowercase letters. On TikTok at King of Hearts 316 2021. You can email me kingofhearts316_09 at outlook.com. If you wanna, if you liked everything you saw and heard tonight, thank you. You can always like, share, subscribe, drop me a comment here or in the community section. I would love to hear what you have to say on everything in this edition of Bethea'S Byte. You can also support me financially as well. I'm only using two of them now. You can hit me up with PayPal me /EKB316 or Cash App $EKB316. But either way, I appreciate the support. Nothing is obligated. It's always appreciated. Alright, let's wrap this up right. This is your home for true crime news without the drama, where your opinions matter, where lively debates are encouraged, where your voice is heard, and above all else, it's justice served. My guarantee, simple. No gimmicks, no drama, no BS. Ladies and gentlemen, this is Bethea'S Byte, and it's reloaded. I'm Ernest Bethea, the last outlaw. Thank you so much, and until we do this again, guys, you all know what to do. Byte.
Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe to the channel, and drop me a comment on this video. Also, be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.